We're ready when you are. Hold on.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Kinder and Ditkoff. We will be hearing 6 arguments this morning. The first one of which is number 20-701, Commonwealth versus WERNER, Garcia, Figueroa. The rules are the same when we hear argument by video conference, which we are doing today in light of the ongoing pandemic, as they are when we are in the courtroom, which is to say 15 minutes per side and no rebuttal. And we will hear first from you, Attorney Mursky.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, Attorney David Mursky for WERNER Garcia Figueroa. The first issue I'd like to discuss is the Miranda issue. The Commonwealth did not meet its burden of proving that the defendant understood beyond a reasonable doubt that the defendant understood his Miranda rights, particularly the right to remain silent, the right to have counsel present during questioning, that there's a stipulated transcript, and there's Detective Chad Bourne's testimony at the suppression hearing in which he clarified a part of the transcript that it erroneously states that it's undecipherable and indicated that which was uncontested, that the defendant asked, "What is this about?" and that the officers told him, "Well, we're going to talk about that." And
Attorney Mursky, can I interrupt with a question?
Sure.
Assuming for the moment that you persuade us that the Commonwealth failed to prove beyond a reasonable doubt that your client fully understood his Miranda right, in light of the evidence in this case, which, as you know, included a videotape of many parts of the assault, and also the evidence that your client's sweatshirt had the victim's DNA on it, how would those statements have made a difference in the trial?
Well, particularly, Your Honor, at the trial, the Commonwealth witness, their main witness, Jose Antonio Sanchez, the decedent's brother, was precluded from making a identification for the record of the defendant, my client, because he was unable to make an out-of-court identification, and an in-court identification thus would have been impermissible as being unnecessarily suggestive. It would have been a suggestive ID, and such an ID, though that isn't the issue of whether to preclude it on that basis. The fact that it's suggestive shows.
Mr. Mursky, I didn't sense from my reading of the transcript that identification of your client was even an issue at the trial.
Well, that the identification that came in at the trial came from the interrogation, Your Honor. That's why the Miranda warnings were more than harmless error.
I thought the victim's DNA, or one of the victim's DNA, was on your client's sweatshirt.
That's the allegation, Your Honor.
Was that evidence rebutted? Was that argued against?
There was a fight, Your Honor. So that would confirm that the presence, but what they gained from the interrogation was the order and the nature of their investigation and placing of events and trying to gain the defendants confirming of their inculpatory accusations of him, and trying to create a timeline which is in what I would call argument in their Exhibit 25, where they've attempted to use maps and very difficult to discern videos, alleging that certain photographic sequences come at certain stages on the maps. And they used the interrogation to try to create their story, which they've alleged, and which is what the Commonwealth has alleged here. What I'm talking about is that in court, that there was a fight, and there could be DNA coming from a fight, from any kind of contact. But what I'm talking about particularly is that you have in transcript day 3, that the trial judge is precluding the co-defendant counsel from attempting to identify my client as a person that struck Jose Antonio Sanchez, and a person who engaged in the alleged events that are charged. And it's an unusual case and an unusual transcript that you have no actual statements where a witness is being asked about conduct, and they're not asked by the prosecutor, and could you identify for the court, or can the court take notice of which the defendant who is being pointed to? You have instead testimony that it's this guy, it's that guy. You don't have definitive statements. It's unusual, Your Honor, and it lacks probative value. It weakens the probative value of the witness, and there's a very good reason for it, because the witness couldn't make out-of-court identifications.
But Mr. Mursky, correct me if I'm wrong, but I thought that each defendant at trial pressed a defense admitting they participated in a fight, simply stating that neither of them intended to kill the victim, correct?
Yes, Your Honor.
So it struck me then that identification and who did what wasn't really an issue at the trial, was it?
Well, that's not true, Your Honor, because we're going back to the interrogation and the whether or not it was harmless error, and it certainly wasn't harmless error to admit improperly in violation of Miranda, admit defendant's statements made during that interrogation during police custody, as it was not simply whether you were in a fight. It was the sequence, the accusations, the attempt to discredit the statements, to create an air of dishonesty being cast upon my client by the police, that would definitely materially affect a jury's decision whether on intent, because what we're talking about here is whether there was just a punch which could have caused the result, or whether there was a second-degree murder. And I also, as I highlighted the issue of ineffective assistance of the trial counsel for not objecting to the jury instruction on involuntary manslaughter, and I'd like to go to that issue if I may.
Yes, I'm baffled by this argument. You say that the judge mistakenly, and I'm not sure this is right, but let's take this for purposes of argument. You say the judge, in giving the involuntary manslaughter instruction, actually required a higher level of intent than it's supposed to.
Yes, Your Honor. And it's not.
I'm totally baffled by what.
It shouldn't be baffling, Your Honor, and you can look specifically at the way I've analyzed the actual words.
Okay, well, what's baffling to me is that you then say that any battery had to be found to be second-degree murder as a result of that misstatement, and I'm baffled by that. So maybe you can explain to me what you mean. You use phrases like irrebuttable presumption. I was just totally confused by this. What is the error, and how does it affect your client?
Okay, well, first of all, the trial judge instructed that the second element of involuntary manslaughter was that the defendant intentionally committed a battery that endangered human life.
Later defined to mean.
And then in the third element.
Later defined to mean something like substantially. He says, right, that's clarified a little later, isn't it?
Yes, Your Honor. It's given as an element.
Okay.
That the defendant knew or should have known that the battery endangered human life in that it created a high degree of likelihood that substantial harm would result to the victim. So
you agree that second part is correct, right? That second part is involuntary manslaughter, right?
There are different definitions of involuntary manslaughter, and what I'm talking about here is and first of all, you can see that there's a problem, and I've pointed it out in my principal brief, that there's a whole problem in Massachusetts distinguishing between involuntary manslaughter and third-pronged malice. But what I'm talking about.
What is that? Because third-pronged malice is plain and strong likelihood that death will result, and involuntary manslaughter is high degree of likelihood that substantial harm will result. One's plainly higher, little higher chance, and higher thing. Death versus substantial harm. What's
it's not simply substantial harm the way instructed here, Your Honor. It's a battery that endangered human life, and endangered human life in that it created a high degree of likelihood that substantial harm would result. So it's equates, and I'm saying it equates for a juror to a plain and strong likelihood that death would result.
Okay, let's
not separating.
Can you please explain? Your time is short. Let's say you're right, and that he gave the equivalent of third-degree malice. So what? How does that hurt your client who was convicted of second-degree murder?
Third-pronged malice is second-degree murder, Your Honor. So
yes, your client was convicted of second-degree murder. Am I correct?
Yes, Your Honor.
How is he harmed by the instruction on involuntary manslaughter if we assume it was an error, which I'm willing to do? I don't understand the harm.
Because his attorney argued for involuntary manslaughter, and by doing so was arguing without knowing it ineffectively for third-pronged malice for second-degree murder. He was trying to avoid having his client convicted of second-degree murder, but instead he argued for it because he allowed this instruction to go forward. And this instruction, instead of giving an opportunity for a lesser included offense, actually created a mandatory finding of by asking for involuntary manslaughter. With that instruction, he's asking for third-pronged malice finding. And the judge instructed, and I pointed it out in the reply brief, the specific instruction the judge gave on third prong malice, which tracks exactly what I've pointed out in my principal brief, where the case that mentions this problem in Massachusetts between these two.
Now, so
Yes.
you're saying that endangered human life is the same thing as plain and strong likelihood that death would result, or at least a jury would have understood it as such? Is that the argument?
I'm saying that the judge defined. I'm trying to answer you, Your Honor, directly. That first of all, the instructions have to be read together, and what I'm saying is when you combine them, a battery that endangered human life, creating a high degree of likelihood, and then where you're defining endangered human likelihood is as creating a high degree of likelihood that substantial harm would result. That is the same as saying it created a plain and strong likelihood that death would result.
All right. I understand.
Okay. Your time has expired. I think we understand your argument better, and we have your brief as well. Thank you very much.
Thank you, Your
We'll hear
Honor.
now from Attorney Steinfield.
Thank you very much. May it please the court, Kenneth Steinfield from the Commonwealth. I'd like just to make two comments on Justice Kinder's first point, that there was no prejudice even if the admission of Werner's statement was erroneous. I'd like to add that the defendant was able to make very good use of his statement in his closing, which he began by saying, pointing out that in that statement, Werner said that he did not want anyone to die and that he was very sad about that. That was the first thing that the defense counsel said in his closing. It was also the last thing that defense counsel said in his closing. So he bookended his entire closing argument and therefore his whole defense on statements made by Werner in that very statement that he sought to suppress. Even if he had been forced to do that because the statement had not been suppressed, the fact that he was able to make very good use of it, in fact, it formed the foundation of his defense, shows that he was not prejudiced by the admission of the statement. My second comment on that is that the defense counsel says on numerous occasions that the Commonwealth used the defendant's statement for certain purposes, that it used his statement to put him at the scene of the crime, that it used his statement to show that he had been in a fight. The Commonwealth never did that. In his closing argument, it said nothing about his statement. It had abundant other evidence, as has been pointing out, most prominently the DNA on his clothes that showed that he was there that night, that he was part of a fight. And so the Commonwealth never used his statement that way.
How did they use the statement? Was the statement admitted? Did the jury see the whole video?
Yes, the jury both saw the video of both of the statements, and also both of the transcripts were also admitted in evidence. So it's a slightly unusual case in which you have both the CD of the interview with certain redactions made and the transcript, which the parties agreed was accurate. So the jury had before them both of them at the same time so they could watch it. However, the prosecutor in his closing argument never asked the jury to look at the tape or to watch the statement. He made no reference at all in his closing to any statements made by Werner in his closing. It was not an important part of the Commonwealth's case. It did show that he had made a lot of lies and that he had said things that were just totally inconsistent with the video, but he didn't focus on that. He didn't even mention that in closing, and he certainly never used the comments in the statement to show that Werner was at the scene of the fight and that he engaged in a fight there. Obviously, the DNA showed that, so there was no use of.
Can I ask you a question about the tape? And I'm not sure, maybe this is subsumed within your brother's argument.
Certainly.
doesn't saying to the defendant, this is the important part, which of course isn't what's, the warnings are set out in Miranda, and it doesn't have a, this is the important part of it. If you say to him that the important part is that he can stop at any time, mightn't that minimize in the mind of the defendant the importance of not speaking in the first instance or not requesting a lawyer in the first instance?
Not the best choice of words, I'll be the first to admit.
Okay.
But if you look at the entire statement, which is on page 4 of the transcript, which is page 141 of Werner's appendix, if you look at the whole thing that Detective Chadbourne said after here comes the most important thing, he said, and this is what is most important. You can also give up your right to a lawyer and your right to remain silent and can answer any question or make any declaration that you want. If you decide to answer questions, you can stop at any time to consult a lawyer or for any reason. So if you decide that you want to talk to us and I ask you a question, but you don't want to answer it, you don't have to answer it, and you don't have the obligation to answer it. That's all that follows the statement. Here's the most.
No, but I'm just a little concerned about blessing this. I think the police are extremely good at following the law when it comes to this, and if we bless this kind of formulation, I'm afraid we're going to see more of it. And I will say, I mean, of course, it's a funny thing. I'm not saying that the officer deliberately, we see these from time to time, and of course the officers want the person to talk, you know what I mean? And so it may be that even unconsciously or whatever, they're the way they're framing it, hoping the person will say, yeah, okay, I'll talk. So that's all. I found that a little jarring to tell him this, the part after you started talking is what's really important.
I agree. I agree entirely, Your Honor. And I'm not asking this court to bless that comment at all. I'm merely saying that in the context of the whole provision of the Miranda rights, this does not preclude a finding that he knowingly and voluntarily waived those rights. It was an unfortunate phraseology, but there are several occasions, during the same colloquy where the defendant makes very, very clear that he understands all of those rights. So I certainly am not asking this court to condone or to add the phrase. It's certainly not the most important right, but in the context of everything both that followed that and that both preceded and succeeded that exchange makes very clear that he fully understood the rights that he had and that he waived them. In fact, Detective Chadbourne on one occasion went farther than he had to and said, you can stop to consult a lawyer or for any other reason, which he was not obligated to say. So I think that overall, this interrogation showed a high level of professionalism on the part of Detective Chadbourne with this one admittedly unfortunate statement.
Can I ask you about severance?
Of course. That's in the other case.
No, I think there's a.
Yes, I'm sorry.
Severance is in this.
I just had SELVIN on my mind for a minute. I'm sorry.
Yeah. So at the end, I think the closing of the brother, SELVIN, can be read. I don't know if it has to be, but it seems like he's saying, look, my guy didn't know his brother was going to murder this guy. Isn't that why we want to sever these cases?
Well, but I think it was more ambiguous than that. First, it was, I didn't use a brick. I don't know what happened.
I know, but the jury is sitting there and there's a dead person, right? And someone killed him. Obviously, there's a question about with what level of intent and so on. Isn't it problematic to have the brother there saying, on top of the prosecutor saying it, look, I don't know anything about my brother's mental state or that he's going to kill somebody.
I don't see how that's especially inculpatory of Werner for SELVIN to have said that. And for Werner to gain relief on this claim, he has to show not only that there was error in the denial of the motion to sever, i.e. that they were mutually antagonistic defenses, but it was so bad that it actually deprived him of a fair trial. So it's not just that he has to show that it should have been severed. There's a very high burden of proof as to prejudice
Counselor,
for defenses on this claim. And even, I'm sorry, Your Honor.
Counselor, what did the judge know about what Selvin's defense was going to be at the time the judge made the decision to deny the motion to sever? That wasn't totally clear to me.
Yeah, no, I don't know either. I don't think that at the time, and certainly we have the record for the motions to eliminate, and I don't think that there's anything said about it. So I don't know of anything on the record that explicitly says she was very familiar with the case and knew that there was DNA evidence and other evidence that placed them at the scenes and that there was a videotape. But I can't answer definitively what her state of knowledge was at the time that she admitted this evidence. However, the defense counsel had the obligation to show to her at the time, you know, why these things. He focused actually at the argument on a possible Bruton problem. That was the major basis for his motion to sever, which never came up at trial. And so it turns out that the thing that he feared the most never actually happened. And so I think the fact that it's something that Selvin's counsel said in closing about he didn't use the brick, I don't think that possibly could have had the prejudicial effect that is necessary to show that he's entitled to a new trial based on the failure of the severance here. If the members of the court have no further questions, I don't have anything to add, and I don't see any reason to waste the court's time for the next 5 minutes.
I see no further questions. Thank you for an excellent argument. Thank you both for excellent arguments. The case is submitted.
Thank you, Your Honor.
The case is now being recorded.
Good morning. Our session continues this morning with number 20-703, Commonwealth versus SELVIN F. Garcia. I should have said I'm Justice Rubin. I'm joined today by Justices Kinder and Ditkoff. The rules when we hear the appeals court hear argument by video conference, as we are this morning due to the ongoing pandemic, are the same as those in our courtroom, which is to say 15 minutes per side and no rebuttal. And we will hear first from you, Attorney Crouch.
Thank you. Good morning, and may it please the court. Andrew Crouch on behalf of SELVIN Garcia, who appeals from convictions out of the Essex County Superior Court. I would like to begin today by addressing the second issue in the brief, namely the trial court's denial of the defendant's request to cross-examine Antonio Sanchez, the key witness for the Commonwealth, about possible areas of bias. At the outset, it's important to note that the Commonwealth concedes that this was error for the court to preclude completely the defendant from cross-examining Antonio about bias, but this court obviously conducts an independent inquiry as well. So in reviewing what happened here, the defense counsel at the appropriate time asked to go sidebar, and then brought up his offer of proof in terms of what he was going to cross-examine Antonio about, and specifically with regards to speaking with an attorney for criminal liability and possible filing of a civil suit. And despite making that offer of proof, the judge completely foreclosed his ability to seek to cross-examine Antonio. As we know and are well aware, the right to cross-examine is fundamental to our criminal system, and especially with regards to potential for bias. And that, the SJC has said that essentially, if on the facts, there is a possibility of bias, even a remote one. The judge has no discretion to bar all inquiry into the subject. And that unfortunately is what happened here. So I think we now move to the next part, which is to look, the Commonwealth will bear the burden of proving beyond a reasonable doubt the harmlessness of this particular error. And when we get into the individual factors, we start at looking at what is the importance of Antonio's role in this case. And obviously he being one of the victims, this case, he has a key role to play here. And I would suggest that in its brief, the Commonwealth, tries to minimize Antonio's role by saying, specifically that, this was a video case, not an eyewitness case. I think that is 180 degrees different from what the trial prosecutor's position was. In his opening, in the trial prosecutor's opening statement to the jury, the prosecutor told them, ladies and gentlemen, you're not going to get the whole picture when you see the videos. And your honors will have the videos in Exhibit 25. You can review them, and you will indeed see that it is not the entire picture. Quite literally sometimes. The individuals and the participants often go out of frame, or they are in a distant part of the frame in a rainy, dark evening. Also, this is closed, circuit TV. This is surveillance video. There is no audio. So the context.
Mr. Crouch, one of the things that everyone seemed to agree to during the trial, largely on the strength of the videotape surveillance evidence, was that your client kicked the victim in the head when he was down. In light of that, assuming that you agree with that, why isn't that powerful evidence that would make less significant Antonio's testimony about what happened?
Certainly, because Antonio is the one who is providing the actual context and the content for what happens here. Because we don't actually know what is said between any of the parties. We only have Antonio's version of what happens here. And what Antonio says is, look, and the Commonwealth uses him as, its key point, which is to demonstrate that the brothers Garcia were the aggressors in this matter, and specifically, that they were bothering Sergio at the bar, and that is why that is why Antonio returned to protect his brother. That they were being mean and belligerent and yelling profanities at them, and essentially, trying to stalk them and locate them, and also to downplay his own role. So they're saying, at this point, that they were not the aggressors. That they wanted to go home. That he was only there to help.
I'm trying to figure out how this matches up, though, with what might have come out on cross-examination. So let's make it the strongest case for you. On cross-examination, what would have happened is that he would have admitted that he hired a criminal lawyer because he was concerned about his own liability, and that he intended to bring a civil suit against the two defendant brothers for whatever his injuries are in wrongful death of his brother.
Yes.
Right. That's about as robust, I guess, as you would hope to get. Right.
And I think it's substantial evidence. And I think the case.
But I'm trying to figure out. So he's concerned about his own criminal liability. So he consults a criminal lawyer. But the video shows, among other things, your client and his brother returning to the scene after being away, going back to the fight. How does I'm having a hard time understanding how that might be undermined, that video evidence might be undermined by Antonio thinking, maybe I have criminal liability here. Can you explain that? Yeah,
certainly. So as we were saying, here, the law is clear that, where there is issues of bias like this, the jury should be allowed to hear that. And I understand that the video does provide at least part of the context and part of what is happening there. But essentially, if Antonio had any motivation to exaggerate, SELVIN's actions, especially leading up to what happened here, and the Commonwealth says SELVIN is an aggressor. SELVIN repeatedly punches Antonio. They set all of this context up in advance to sort of get us to the point of a first degree, or in this case, a second second-degree murder conviction and determination. But if Antonio has any reason, any motive whatsoever, and again, the case law doesn't suggest that we have to show that it is likely that the jury is going to believe that or anything. It just has to be just even, the possibility, even the remotest possibility that, the jury might consider the issue of bias. But if he has a motive to downplay his own action.
Yeah, but I'm trying to figure out, right, there is this question of prejudice, whatever the standard is. And I'm just trying to figure out, okay, so he was concerned about his own liability because he was the first aggressor. He wasn't defending himself, he was the aggressor. But then there's all this video.
There is the video, and I think that Werner's case is a different case from Selvin's case, quite obviously on the video.
Sure.
And Selvin's role on the video is far more limited. And as you said, we're focusing on this kick. But the point is that based upon the record, neither we nor the trial judge would know with certainty, how specifically how he would answer those questions or what the jury would do with it. Now, the jury is entitled to be able to weigh the entirety of what Antonio might have to say and the entirety of whether or not he has any motive to suggest that they just suddenly started fighting with us, which colors the entirety of what happens to follow. We also don't know, because we don't have any audio whatsoever, what is said between the parties. Selvin and his brother are saying in their statements that it is that Sergio or Antonio are making statements to them, and that they that Antonio is the one who is beating up on Selvin. Selvin's having a wholly separate fight and argument with Antonio. But if the jury is not able to know whether or not Antonio had any motive to exaggerate Selvin's actions, or to downplay the mutual nature of the altercations, or to characterize his own actions as self-defense in order to bolster either a monetary recovery or to protect himself against criminal liability.
Mr. Crouch, I'm sorry to interrupt when you're on a roll, but when we get to the point of the kick to the head, when the victim is down, I'm having a hard time understanding the importance of the context leading up to that.
Well, I think that part of the context is that Antonio is constantly saying, they're trying to stop, Selvin's role is essentially trying to stop me from getting to my brother. So this goes not just to the kick, which we, contend could be considered independent of, the other actions, but he's saying that Selvin's role is essentially as a gatekeeper, that he is able to stop Antonio from assisting his brother coming to aid. And therefore that's the whole basis for joint venture in the case. Because when we look at the rest of the video isn't showing Selvin doing very much. And I would suggest, looking at that initial altercation outside the bar, both Selvin and Antonio go off frame, not throwing punches or doing anything in particular. They're just kind of going after their brothers. But you hear Antonio's version of events, and it is radically different. It is that Selvin is assaulting him multiple times, and that Selvin is the aggressor the entirety of the time. And I would suggest the video at times is incomplete. There are full sections of time that are missing. Sometimes it's hard to read. It's a bit indecipherable, and we have absolutely no audio with regards to it. And so I think that in this circumstance, where there is the possibility for bias, and indeed we do see that they file a civil lawsuit 4 months later, there's an opportunity here that was required, for him to be able to cross-examine. And as we look at, the courts, in looking at the additional factors here, one of I think the key factor that the Supreme Judicial Court has suggested is the second one, which is whether or not the testimony was cumulative. And the court has said that, when we have decided that a trial judge committed no error or only harmless error in striking questions by a defendant designed to impeach a witness's credibility, it has been because the equivalent information was communicated to the jury. This is not a situation where any other additional evidence with regards to Antonio's potential for bias was communicated to the jury. It was completely foreclosed in this instance. And this is, the Commonwealth cannot and does not attempt to argue harmlessness on this particular point. And it's important to keep in mind that indeed the Commonwealth bears the burden here of demonstrating this harmlessness beyond a reasonable doubt. And we look into the third factor, specifically, the presence or absence of any corroborating circumstances contradicting the testimony of the witness on material or key points. And here, as you said, we have some videos, and as I said, they are incomplete. We have a 911 tape, but again, Antonio is saying certain things on the 911 tape that don't match up with what what the testimony is later. He tells them that indeed there is no weapon. There's no weapon used whatsoever. The Commonwealth goes in the complete opposite direction, says, no, a brick was there, the brick was likely used. And then at trial, he's suggesting, they hit me with a brick. So indeed, cross-examining him on why his story is changing on some of these points, that story may have changed in part because he's trying to either minimize his own criminal liability or potentially to maximize any kind of a financial incentive to file a civil suit after this is over. And then, as I said, we look at, that final point as I think we've discussed, which is the overall strength of the prosecution's case. And I would suggest, as I've said, the video evidence is only part of the story. It does not tell the full tale. This is not a circumstance where the entirety of the events were contained within the four corners of a video that we can simply look at and judge as any participant or witness could in this circumstance. Antonio is key to the Commonwealth's case, and they can try to minimize his role, but in the end, he is the only person who is able to testify as to large portions of the fight, to actually be able to provide the context and the content for what is happening between these parties, what is said, and he frequently downplays both his role and Sergio's role, while also playing up the roles that the brothers Garcia played here. And accordingly, this is a circumstance where the judge, in completely foreclosing what was not a remote possibility, but indeed, a likely possibility of Antonio's bias, completely foreclosed it. And this was not a certain. The case law makes pretty clear that this is a serious constitutional error. It is one where there are limited circumstances under which this couldn't be found harmless. And in foreclosing, this does not allow the jury to make any kind of a discriminating appraisal of the possible biases and motivation of Antonio in terms of what he could do in this particular case. And so
you didn't file a reply brief. In their brief, the Commonwealth purports to distinguish Gilliard on the ground that there was an involuntary manslaughter instruction in this case. Do you have a response to that?
This is going to the...
Yes, the first issue.
Okay, sure. Yes, I would suggest, the Commonwealth is looking at cases, cases such as our. I think that, the important thing to look at here is the case of SELVIN Garcia is distinguishable from a lot of the cases that the Commonwealth suggests.
I asked a specific question and you don't have much time. In Gilliard, Justice Kaplan said that they could have skirted the manslaughter instruction because there was a requirement of showing provocation, as there is with voluntary manslaughter here. The Commonwealth says, but there's also an involuntary manslaughter here with a lower mental state than second-degree murder, which would have been an option, yet the jury did not choose that. So they certainly wouldn't have chosen the even lesser option of assault and battery, even if it was should properly have been instructed on. What's your response to that?
I think, the response with the time I have here is that, assuming the jury avoided, finding manslaughter, or assuming that the jury in this circumstance, could have found manslaughter, I think that the evidence, as we see in this particular video, could suggest, I think, still supports the possibility that they could have gone down to assault and battery simply based upon the circumstances of that one kick at the end. And looking at the rest of the video, it suggests that he did not have other involvement, and I would suggest, again, this wraps in a little bit with the second issue, because they didn't know what other motivations Antonio might have had. So I would suggest that.
Okay, but my question is, since the point is all or nothing, that's the risk. The risk was without this instruction, they would have done all or nothing. They didn't do nothing. They did second-degree murder. They didn't do involuntary manslaughter. Do you have a reason why you think they might have done assault and battery if they didn't go down to involuntary manslaughter in the first place?
I think, and as I said, it's obviously impossible to know what the jury is thinking in particular circumstances. But I think that the law is clear that where the evidence taken in the light most favorable to the defendant, as for the reasons we've discussed throughout the argument here in terms of what SELVIN did, I think that the instruction on the lesser included offense of assault and battery should have been given under the circumstances.
Okay, thank you very much. Your time has expired. Excellent argument. We will hear next from Attorney Steinfeld.
Thank you very much, Your Honor. Kenneth Steinfeld for the Commonwealth. I'd like to focus the court's attention now on the volume of evidence of malice, of SELVIN's malice, based solely on the videotape, independent of any of Antonio's testimony. And I think that goes a long way on both of the claims. The first claim that he should have received the lesser included instruction of assault and battery, and the claim that he was prejudiced by his inability to cross-examine Antonio on his possible bias. The video showed that WERNER made the first punch. He punched Sergio while Sergio was standing in the doorway with his hands in his pockets talking to him. So WERNER was the first aggressor as shown on the video. The video also showed SELVIN following after them to help his brother. The video also showed that that they left the scene. Both defendants left the scene, and that 6.5 minutes later, they were waiting a few blocks away, lying in wait, and that as soon as the victims, the fatal victim and the non-fatal victim, showed up and started to walk down the street, they accosted them from across the street, ran over to the other side of the street, and then started to beat them. And of course, a lot of that beating did occur in the parking lot behind the jewelry store where there was no video, but certainly the video showed undoubtedly that the brothers, the defendants, were the aggressors during that attack. You have the 911 call in which Antonio says the police are on their way, they're on their way. And so ultimately, both defendants leave the scene, and when they leave the scene, Sergio is lying face down. That's on the video. I agree with both of my brothers that the video is hard to follow, but I would add it's hard to follow at first. If you watch it 50 times, and I have laid out in my brief very, very carefully what is on the tape at what point in time, both according to the counter on the video itself and the timestamp. If you watch it over and over, you will see very, very clearly Sergio's body lying face down on the sidewalk behind the parking lot of Omar and Oscar's. So the second time when they leave, following the second attack, which the defendants have initiated, they run around the block. And I've asked the court to look very closely at the video of them sprinting by a Domino's on the other side of the block on their way back towards the scene where they have left Sergio lying face down. And then it shows them, showing that they are intent on going back to the scene fast because they know that the police have been called, so they don't have much time. But the best piece of evidence, actually the two best pieces of evidence of malice that come from the video are, as I say in my brief, the video of them walking up Blake Street after they've turned the corner and they're approaching, and right in front of them, the video shows Sergio on the ground face down and his brother hovering over him and trying to assist him. And WERNER and SELVIN pick up their pace as they're walking towards them. Both of them simultaneously put up their hoods, and SELVIN taps his brother WERNER on the back as if to say, let's go get him. It's a very, very clear statement of what's going on here. And then of course, when they get there, they go after Antonio. And then after Antonio escapes, they have an opportunity yet to leave again, and they don't. And then comes the kick. And I think the kick is huge evidence. It is irrefutable evidence. It makes it very difficult for any finder of fact, I think, to find that they had a lesser state of mind than malice when they kicked a poor, defenseless, immobile Sergio on the ground. And I've cited a bunch of cases to stand for the proposition that in circumstances where a victim who is in that position after a beating gets kicked in the head, that malice is the state of mind that indicates.
Mr. Steinfeld, you, in your brief, and you've mentioned it this morning, refer to the defendants as laying in wait for the victims. And as I understood the record, they left the scene of the initial confrontation and moved in an opposite direction from the victims. And it wasn't clear to me from the record. We know they met up again, but it wasn't clear to me from the record how we could conclude that they went to a location where they were laying in the wait and in wait, that is, and how they would know which direction the victims were going.
Well, as to the first point, the video showed that they went the same route. First, they went up Monroe Street or right onto Central Square and the left onto Blake. And they stayed there for 6.5 minutes. I mean, there was a long period of time there where the victims were trying to find their glasses. So they were there when they got there. And I candidly admit that we don't know how they knew which direction that they intended to travel. I mean, that's just not in the record. But nonetheless, they were there waiting for them 6.5 minutes later when they walked down the street there. So I think it's fair to characterize what they did there was laying in wait, especially given how they immediately accosted them. And I think that you could deduce that they were expecting them or thought that they might, at the very least, be going that way. They had said that the place to get a taxi was on South Union Street, and that where they walked was in the direction of where South Union Street was. So perhaps, and this is, more speculative than I might like, they might have thought that perhaps that they'll walk this way in order to get a taxi. But as I said, we don't know. But the fact remains that 6.5 minutes later, when they could have left the area, gone anywhere they wanted in the city of Lynn, they just happened to be across the street on the same street that the victims happened to walk up 6.5 minutes later.
Did Antonio's story about the brick change?
No. When he was on the phone with 911, he did not see a brick, and there's no evidence that a brick had been used at that time. He said that he was later struck in the face by Werner with a brick. So it's clear that at the time that he made that statement, they have no weapon.
When he talked to the police, he had not been hit in the face.
That's correct.
That he lost some teeth or had broken teeth or something.
That occurred.
I see.
That occurred later. So there's no inconsistency whatsoever. Also, if you look at the video, and also there's another video that's introduced in evidence that I have not asked the court to look at, but again, if it want, that's a crime scene video that was taken by the police that shows the rain that this was a very, very rainy night at that point. And so from where Antonio was in the sidewalk, not a well-lit, in the street, down Blake Street, it is certainly plausible, if not likely, that if Sergio had a brick in his hand at the time he was assaulting Sergio, Antonio would not have seen it. So no, Judge, there's no inconsistency whatsoever in Antonio's testimony about the brick. I also wanted to add that if Antonio had intended to gild his testimony so as to assist a civil suit, he could have done a lot more, and he presumably would have done a lot more. He said, frankly, that he didn't see a lot of what happened with Werner and Sergio in the lot because he was dealing with Antonio. And he certainly would have said, or he might have said, I saw him hit him, I saw him strike him, I saw him beat him. He didn't say anything like that. And there's nothing in the defendant's brief that shows any major inconsistencies in his story from before, from his statements to police earlier and his testimony at trial, showing that he might be exaggerating his testimony. But I think the fact that his testimony was, I don't know, on a lot of points, and he didn't see, shows that he was in fact being candid and that he was not under the influence of the lure of money in the civil suit when he gave his testimony. That's all I have to say about that issue, and I am happy to rest on my brief on the first one, unless the members of the panel have any further questions.
Again, I see none. Thank you very much both for excellent arguments. The case.
The case is now being recorded.
Good morning. Our appeals court session this morning continues. I am Judge Rubin. I'm joined today by Judges Kinder and Ditkoff. And we are hearing argument by video conference due to the ongoing pandemic. Our rules for argument by video conference are the same as the rules in our courtroom, 15 minutes per side and no rebuttal. The next case is number 20-1197, Commonwealth versus McNeil, and we will hear first from you, Attorney Marks.
Good morning, Your Honors. May it please the court, Daniel Marks on behalf of the defendant appellant, Michael Johnson-McNeil. Your Honors, this was a murder case, and Mr. Johnson-McNeil was found not guilty on all of the murder charges, and those included murder, attempted murder, and accessory after the fact. He was found guilty of 3 firearms charges, 2 of which had nothing whatsoever to do with the shooting. Now, understandably, at the trial, everyone was focused on the murder charges, not the firearms charges, and applying the familiar Lattimore standard. Looking back at that evidence, it was plainly insufficient to sustain any of the firearms convictions. Those firearm convictions really relate to—
You don't have to, but did you move for required finding of not guilty at the end of the Commonwealth's case and at the end of the case?
Yes, Your Honor.
Okay.
The firearms charges really relate to 2 separate cases, and that's an issue in the severance issue presented to the court. The first relates to what happened on July 11th in Dorchester, and that was the shooting on Bailey Street. There was a .38 caliber Taurus pistol used in that shooting, and Mr. Johnson-McNeil was convicted of constructively and jointly possessing that gun, despite the fact that there's no evidence whatsoever he was ever even in the presence of that gun, much less held it or used it or had the intent to do so. That gun was not found at the scene of the shooting on the day of the shooting. It was found 2 days later when other men, not Mr. Johnson-McNeil, were involved in a high-speed chase with the police and threw the weapon out a car window. The second set of firearms charges, which include both firearms charges and ammunition charges, are entirely unrelated and relate to a different weapon, a .38 caliber Ruger pistol found in a private home in Mattapan 4 days later when a search warrant in an unrelated investigation was executed at that home. That was not a gun used at the shooting on July 11th. Now, before I address the firearms charges in detail, and explain why the evidence doesn't satisfy the elements of constructive or joint possession, I just want to say a word about the shooting itself, which was obviously the core of the case. The evidence was at best thin and vague on what happened on Bailey Street on July 11th, and that probably explains why the jury found Mr. Johnson-McNeil not guilty of all those charges. At the end of the day, despite the evidence and all the testimony, including from at least one of the victims, no one really knows what happened on Bailey Street. No one knows who shot first, who shot who was holding which gun or shot it, or why the fatal fight even broke out in the first place. There's witness testimony from at least 2 witnesses, one an independent bystander and one an individual who was in the car, the red Mercury, where the decedent was, who suggests that this was an unfortunate chance encounter after people bumped into each other on the street. No suggestion that this was some sort of premeditated event or that anyone arrived at Bailey Street with any kind of intent to kill.
Counselor, is that really solid when 2 cars come to the area and one person gets out of each car, they engage in the encounter, and then they both get in your client's car? Doesn't that suggest not necessarily a plan to murder, but a plan to have some sort of encounter?
Well, it suggests that they're doing something together. I certainly agree with that, Your Honor. There's video evidence that 2 cars show up on Bailey Street with 4 individuals, to get out and walk up Bailey Street and out of the frame. And this is Exhibit 157, the angle from the VW, the nearby VW post. And if the court hasn't reviewed it already, I urge you to, because I think it really betrays the weakness of the Commonwealth's case. But yes, two individuals get out of two cars and walk up a street. About a minute later, after shots have broken out in the neighborhood, those men are seen running back to a car, get in the car, and leave. Why they're there in the first place? Now, these individuals all live in the neighborhood. They're all social acquaintances. They're friends. What they're doing, whether they're going to the nearby Dunkin' Donuts. There's testimony that one guy is on the scene because he's going to pay a cell phone bill. So yes, there's certainly evidence that they're engaged in some kind of joint activity. They travel together to this location, but that isn't nearly sufficient to establish a joint venture guilt beyond a reasonable doubt of murder or even possession of a weapon.
Now, I don't know why you're fighting about murder. It seems like you've won that case.
Well, because
can I ask you about joint possession, though? Do we have published cases of joint venture possession of a firearm where, so far as we're aware, the firearm is solely in the possession of one of the two people, that it's not loose in a car or in a, someplace where they both have access to it? Are there cases like that? I mean, I'll ask your sister as well, but.
Yeah, it's no particular case is coming to mind where a joint venture conviction is affirmed on that sort of fact pattern. The case law is, well, you say the case law could be a bit clearer on the distinction between joint venture possession and constructive possession. Here, I don't think that the court really needs to tease out any subtle distinctions, because as the Commonwealth acknowledges in its brief and concedes, in order to sustain these convictions, they need to establish guilt beyond a reasonable doubt on both theories.
Counsel, let me stop you there. The Commonwealth does concede that, but even if the Commonwealth conceded the conviction be reversed, we couldn't just accept that. And wasn't that case law reversed in Zanetti, overruled in Zanetti? And didn't we find in Ormond O that even in a possession context, you only have to prove sufficient evidence of one of those things? So yes, I do believe that there is case law that says that joint possession alone would be sufficient. That's not the Commonwealth's position here, or the position it took below, or how the jury was charged. But then we're presented with the problem of what that means, separate and aside from constructive possession, in a situation where no one is suggesting that Mr. Johnson-McNeill himself personally did anything with the firearms at issue. The entire
Mr.
argument is based on
just following up on Justice Rubin's point, the Commonwealth cites the Mendez case, which, as I understand it, stands for the proposition that there can be joint venture liability for an individual who does not have actual possession when that individual, at least in that case, was acting as a lookout. Why doesn't that case have some impact on the facts before us here?
So, Your Honor, if the evidence was sufficient to sustain a finding that, in fact, Mr. Johnson-McNeill showed up at this location with the intent to participate in some kind of violent crime using that firearm, then I think Mendez would be a helpful case for the Commonwealth. The problem is that's not what the evidence shows. And in fact, the jury rejected the Commonwealth's theory that that's why everyone arrived at the scene when they found the defendant not guilty of the murder, which, to Justice Rubin's point, is why I keep coming back to that. It's impossible for the Commonwealth to establish any kind of concerted action sufficient to establish joint venture, separate and apart from its theory, rejected by the jury, that these individuals showed up at Bailey Street in order to shoot someone with the gun. And the evidence simply didn't establish that. Your Honors, with respect to July 11th, I'd also add that the notion here, and the suggestion is made in the red brief, that the evidence established at trial that Pereira was the shooter, and that Pereira left the scene of the shooting and got back into Michael Johnson-McNeill's car with the gun. The problem is that, again, that's not what the evidence showed at trial. There was no evidence of who was the shooter, and no forensic evidence, DNA, fingerprints, ballistic evidence that linked Pereira in particular to the shooter.
Isn't that a reasonable inference from the fact that the shooter is either Pereira or Huggins, and only Pereira is there when the gun gets tossed?
No, Your Honor, I don't think it is, because I don't think it's necessarily true that one of those men was the shooter. There are unidentified shells left at the scene. There are multiple witness statements that the shooter was someone in a black shirt. I think one thing that we can all agree on is Exhibit 157 makes very clear, beyond dispute, that the two individuals who got out of the blue and black BMWs on Bailey Street were both very clearly in white T-shirts. They simply don't match the description of the independent bystanders who saw a shooter in a black shirt. So it's very unclear. And as far as Michael Johnson-McNeil knows, because again, we come back to whether or not he knew there was a firearm, whether he had the ability to control that firearm, and whether or not he had the intent to do so. And even I don't even think the Commonwealth gets out of the gate, Your Honors, because there's no proof that he knows Pereira is the one with the gun around the corner on Bailey Street, much less he knows that when Pereira comes back and gets in his car, he possesses a gun. The Commonwealth points to things like, well, they leave the scene. Well, of course they leave the scene. There's been a shooting. That doesn't prove that he knows Pereira gets into his car with a gun. They point to the fact that people are talking on the phone. Again, completely innocent behavior, no indication. There's no evidence as to what anyone may have said on the phone or whether anyone discussed a gun or getting rid of a gun. So I think it's at best maybe a reasonable inference that Mr. Johnson-McNeil knew there was a gun. Maybe he knew that one of the guys who got back into his car had a gun, but then the Commonwealth needs to go much further. And this court has not hesitated to reverse convictions when the Commonwealth can't sustain the other elements of constructive possession that had the ability and intent to control that weapon. And there's simply, the record is just completely silent as to those elements. And even in the red brief, the Commonwealth simply asserts if Pereira got back in the car with the gun, ipso facto, that establishes that Mr. McNeil had the ability and intent to control it. But the case law is clear that much more than mere presence is necessary, even within a vehicle, in order to establish ability and intent to control. Your Honors, if I may, I just want to shift for a minute to what happened on July 15th. Again, this is, there's some effort in the brief.
Counsel, before you get into your groove, I've got a factual question that's troubling me, which is that your friend says that the defendant on his interrogation admits to living at that place where the Ruger's found. Is that correct? I have not watched that DVD.
So you're talking now about the 15 Violet Street address in connection to the July 15th gun?
Yeah.
Yes. He admits that from time to time he lives at that address. His mother also lives in the neighborhood. He also lives with his mother. But yes, we don't dispute that from time to time it's his grandfather's house. He has access to the house, and he occasionally stays there. And in fact, the car.
Well, there's testimony from an officer, I thought, allegedly from personal knowledge, that around this time that's primarily where he stayed.
I think that's right, Your Honor. That is true.
All right. So have we ever held that having a gun and ammunition in your own bedroom where your ID is found isn't sufficient to show possession? Is there a case like that?
Yes, Your Honor. There are cases like that, and the reason why is because although let's assume for the purpose of this discussion that's his residence. Let's say it's his only residence.
Let's say it's his bedroom. Yeah. Okay.
Well, it's not clear that this room is his bedroom. That's what the Commonwealth calls it. He says he lives at this house.
Okay.
It's not clear whether he lives in this room, other people live in this room, who has access to this room.
Let's say the jury could find that it's his bedroom. I'm not sure they could, but let's say they could. Now,
right. So, okay.
Let's keep going.
Right. So then we go on to the further question of whether or not it was reasonable for him to know of the contents of everything in his bedroom. Now, we have to step back from the fact
it's out in the open on a futon.
Well, yeah, absolutely, Your Honor. But remember the context for what happens here. The testimony is what happens is that Pereira and Johnson-McNeil are observed going into the home. They spend about 20 minutes inside, and then they come out. After that, a search warrant is executed, and a gun is found partially concealed in a futon in what, let's call it Johnson-McNeil's bedroom for now. The problem is there's no evidence about what happens in the house. No one sees the two men in the house. There
never is.
I respectfully, Your Honor, I disagree. There could be all sorts of evidence about witness testimony about who's seen in the house, whether two guys go into a room together. Pereira could have testified.
We don't know that the gun was even brought in right then, right?
Absolutely right, Your Honor. We don't know that, which is the problem, is we don't know, and the record does not.
But I'm trying to figure out, guns are found in houses all the time. Someone possesses them.
Yes.
Right?
Right.
What's enough to show the gun we found in your house? We're charging you possession of a gun.
Right.
I mean, you can always say, no, the cleaning person left it there or whatever.
I don't know that there's a case that deals with it in the context of a home, but there's certainly cases that deal with it in the context of a car, where the SJC has rejected the notion that ownership and even operation of a vehicle does not establish legal possession of a firearm in that car.
This is someone's bed. That's why I'm asking.
Right. So here, given the facts, I think it's certainly plausible. I think it's equally plausible the inference that the two men go inside. Johnson-McNeil, for all we know, is getting a snack in the kitchen while Pereira leaves a gun upstairs in a bedroom. Now, even if you could infer in that situation, and I would say it's speculative, that Mr. Johnson-McNeil knew the weapon was in that room, again, knowledge is not sufficient. And the question is, where in the record is the evidence that he had the ability to control a firearm that Pereira supposedly left in his bedroom? There's no evidence on that point, and that's why the conviction cannot be sustained. I see my time.
All right, we have your brief is excellent. We have your other arguments there. I don't see any other questions, and your time has expired. So we will hear now from Attorney De La Tour.
Thank you, Your Honors. Good morning, Your Honors. May it please the court, Monica De La Tour on behalf of the Commonwealth. I would also like to acknowledge the victims in this case and their families. The Commonwealth is respectfully requesting this court to affirm the defendant's convictions. And here, in the light most favorable to the Commonwealth, there was sufficient evidence to find the defendant guilty of the firearm possession on July 11th, 2015.
Let's talk about that one first. Because there's several issues here. Has any court in the Commonwealth, an appellate court, ever held that having someone in your car in possession of a gun puts you in possession of that gun?
Purely alone by presence of the car, I would say no. There has to be some other indication.
But in any circumstance, because this is not a case like the many cases we see where a gun is found in a car. It's in the middle compartment. It's in a hide somewhere. It's in the back seat. It's under the passenger seat. It's right. And then we try to figure out who can be said to have possessed the gun. He's the driver of a car. Sure. But all we know is if this gun was in the possession of, let's say, Pereira, is that Pereira got into his car with the gun. And at one point you say that he exercised power and control over the gun. It sounds like by driving the person who possessed it around. But I've never heard of that as a theory of the driver having possession of the gun. I would have thought we'd say, well, the passenger possessed the gun and the driver drove the passenger around.
Sure. So I think what we have here is consistent with cases like Commonwealth versus Jefferson. It's cited in our brief. It's 461 Mass 821, where the driver's actions, like the defendants here, shows that there's an intent to control the firearm. And here in particular, we not only have that there were phone calls beforehand between the defendant and the shooter. We have that the shooter then circled the location of the victim inferably in the defendant's car, excuse me. And we have that there were communications between the shooter and the passenger of the blue BMW. And that's important because those two cars arrived together despite the fact that there's no communications between the drivers. And I would also note to the fact that the driver here remains with his foot on the brake lights. The car is idling, so he's in a position to flee. And also important is the location of the car. So there's a number of exhibits that show that there's a bend in the street, and there's testimony that where the defendant has parked his car, which is seconds walk away from behind the victim's car, they can't be seen because of the bend in the street. There's a couple of exhibits. 270.
De La Tour,
yes.
Excuse me if I'm misunderstanding your point, but Mr. Marks makes the point that all of those facts in support of joint venture liability on the murder were apparently rejected by the jury. What do we do with that?
Sure. I mean, I would note that the acquittals here don't play a part in the sufficiency analysis. We're looking at the analysis of the evidence before the time that the jury deliberated. And here, all that evidence in the light most favorable to the Commonwealth show that this was a plan to be a fast and deadly ambush by shooting. That, again, that the defendant remains in a position that he would be able to flee. I would also note that if you do look at Exhibit 157, the blue BMW who is in front of the defendant's car actually drives away, and the defendant moves up in his position. So he's actually taking a closer position to the victim's car, again, enabling for a quick and fast.
I don't know. I'm looking at Jefferson, and Jefferson, it's a gun thrown from a vehicle, right? And it's they think it's thrown by the passenger, maybe because of where it lands or which window is open or something.
Correct.
But so for everything that appears here, the gun was on the person of someone other than the driver. And I've just never heard of that as a theory of that the driver possesses it. It seems like the passenger possesses it. And are you saying that anytime someone gets in a car with an item and you know they have that item, you now possess it? Is that the Commonwealth's theory of this case?
I don't think we could go as far to say that. I think that would get into contradiction to cases like Romero, which I believe my brother cites in his brief, where beforehand the defendant knew that somebody was going to have a gun and the person was in the car and they merely just drive them somewhere. Again, it's the actions of the defendant here that put him in this position that show that this was intended to be a shooting. I believe Romero actually.
But I don't understand. Intended. I'm just confused now. Maybe I'm making this mistake you say we're making of looking at the fact that he was acquitted of the murder, but he's someone shoots someone and then gets in his car. And you're saying because we know that they made plans in advance, he must have, I guess I'm not sure what. No, so let's say he knew that the person had a gun. Both when I don't know if Pereira was in his car when they got there. I don't remember whether they switch or how it works. But so he knows this person has a gun because they're going to have a confrontation someplace with a gun. But it's not his gun. He knows this other person has it. Is that the theory? That because he desires the confrontation, he has the ability to control the gun? Does he have the ability to control the gun? I mean, if he tried to take the gun from Pereira, I don't know what would have happened, but possibly Pereira would have said, keep your hands off my gun, right? I mean, I don't know.
I do think that this is partly that there are two different, to be clear, there are two different theories here. The joint venture being that the defendant had the intent for the crime to succeed, which I would suggest is clear from those facts beforehand, also about the fact that the defendant—
Wait, the crime of possession of a gun.
Correct. Well,
every time I let a guy into my car, which I never do, who's possessing a gun, do I have that intent? I want the crime to succeed. I haven't done anything to stop it. Listen, do you mind? I'm going to get in your car. I've got a gun on me. Is that okay with you? Now, am I guilty of possession of a joint venture possession of his gun?
Perhaps if there's a conversation beforehand about where the gun is going to go, here that it's the facts, I understandably that he was acquitted of the murder, the facts of what occurred immediately after the defendant stopped his car support that he had the intent for this crime to succeed. I would say
the crime of murder.
Yeah, so that a shooting was going to happen. So it's subsumed
into— I'm having a very hard time seeing how he possesses the gun. I get that maybe he knows there's a gun. It's this idea of joint venture possession, frankly, I find very bizarre. I mean, if it's loose in a car, okay, but if it's on one person's person, we don't usually say they both possess it without, if we knew more, they both went to the store and bought it. They both own it. And they say, listen, Phil, can you hold this for me? Or you be the one to hold the gun. But someone else possessing a gun inside your car, I've just never heard of that being possession of a gun.
I mean, I think the cases, understandably, there aren't published cases, and I would agree with my brother, there aren't published cases affirming convictions in this way, but I do think some of the joint venture cases, and I think Humphreys really discusses this too in the situation, allows for this to be
Counselor,
allows for this.
I thought Mendez was a joint venture gun possession case. where the
That's true.
gentleman that touched the gun, just was part of the armed robbery, or was it armed robbery?
I believe it was a, yeah, sorry, excuse me, it was an armed
Wait,
robbery.
aren't they trading guns for drugs or something there? And weren't
There
there
is-
3 guns purchased and 3 defendants? And so the theory maybe was that there was 1 gun for each of them or something? I mean, it's not like this, like a shooter gets into my car and now I'm charged with possessing his gun.
I would agree that in Sanchez, or excuse me, in Mendez, that there was an agreement, there was some evidence of the of the purchase of the weapons beforehand. But I suggest that what we have here, again, with the planning, the communications that we have between the defendant and the shooter, that it's akin to what occurred in this case. That because of the fact that he has parked in this location, the defendant immediately gets out of the car, he stays, remains at the scene, moves up closer to the victim's car in order for the shooter to get back into the car. That is akin to the situation that we have here. I would, like I said, I would agree that there isn't a published case, most of the case in terms of affirming most of the cases.
And what is the evidence of, oh, your point is, I guess, so do you have to prove that he intended to exercise control over the gun? Or you just have to prove that he assisted someone else? What do you prove? Right, I mean, I get it. If you say to me, look, Pereira exercised control over the gun, but this was someone who shared, I guess, Pereira's intent to possess control over the gun. But I'm not saying this guy could do anything with the gun. Pereira had complete control of the gun at all times. Is that enough, or do you have to show constructive possession?
I don't think you have to show constructive possession. No,
I thought it was your position that they were the same in this case.
I think the facts that point to joint possession, or excuse me, to joint venture in this case, also support the position of joint possession. I think that's partly where there may be some sort of
Okay, I
melding
have
of
a
the.
hard time getting to constructive possession. It should be clear. I don't quite get that. But I guess if you have someone with you who possesses a gun, I'm thinking about Zanetti now, which of course I can't say that any of us can make heads or tails of exactly, but there it is. Okay, so under Zanetti, now I have in my car a possessor of a gun, and I love that he possesses the gun, and I hope he'll do something with the gun, so I share his intent to possess the gun. Is that all I have to show? That he, the third party, has control? Or do I have to show that I have the ability to exercise control?
I would say under a joint venture theory that you do not have to show that the defendant in this case, or the individual, has to have control over the gun. Over on a joint possession theory, that you would have to show that there would be intent to control a gun. So I think that.
Do I have to show, I hate this, but do I have to show that the defendant knew that the actual person possessing the gun didn't have a firearm ID card?
That's not necessary under Humphreys unless the defendant raises the defense
How
of a
can
license.
it not be necessary for me to have the requisite intent? Doesn't my intent have to include unlawful possession? I mean, if I'm lucky enough to have a friend who has a license and a gun, right?
No, I see your Honor's point. I think Humphreys discusses this. I think it notes that this generally wouldn't be common knowledge with the defendant, but they don't note that the defendant needs to have knowledge. So that I think that's partly why that the defendant doesn't need to have knowledge of an unlicensed firearm, because in many situations that actually wouldn't be the case. And in balancing that between the fact that the defendant.
Well, how can it be that I'm putting someone in jail? All right, a guy gets in my car. I carry a lot of cash. And so I want to bring with me someone who can protect it. And my friend Phil says, I got a gun. And well, you're driving through bad areas. And I know you have all the cash. Why don't I come in the car with you? And I say, that's great. That'd be very helpful. Surely it matters whether I know that he's licensed or unlicensed. Whether you can't, right? It turns out he's unlicensed. Are you going to put me in jail? I certainly knew he had the gun. I was delighted about it. I hoped he would use it to protect me. But if I don't know that he is unlicensed, how can I have the requisite intent? how can I share the intent to commit the crime with him?
Well, I think it's not the intent to I see what your honor's point. I think it's not that there needs to be knowledge of the gun to be unlicensed, that there's knowledge of the possession of the gun. And that's the reason that the defendant would need to bring the potential of a defense of a license in order to shift the burden to the Commonwealth to show that indeed the defendant was not, I'm sorry, excuse me, not the defendant, but the third party was not licensed.
Well, I don't know how it is if it's the actual possessor, but it seems very odd to me that we would require someone who thought someone was helping them out with a gun. Let's say I hire Brinks to come and protect my ATM machine. It turns out the guy is unlicensed. Surely we're not going to say, I have to raise as a defense. Was he? And even then, you'd be able to prove he was unlicensed. But my intent, I don't know. You have very little time, and I've spent a lot of your time on this. Can I ask you this? If we disagree with you that the July 15th possession had anything to do with July 11th, and we think they should have been severed, why isn't telling a jury that's hearing a mere possession case all about a murder, why isn't that prejudicial?
Well, I think in this case, they were certainly connected in the sense that—
Okay, I just said if we assume they're not connected at all, would it be prejudicial not to sever?
Well, certainly not in this case. I would because for a couple of reasons. First, the fact that the jury did acquit the defendant of the homicide charges here.
Yeah, but maybe they thought, wow, but he did something really bad. We better convict him of something like possessing the gun in Pereira's pocket and this other thing on the 15th.
Well, I frankly would think that would be speculating. I think here the fact that they acquitted him of the homicide and the attempted armed assault here show that the jury considered these charges separately. I also would note that the verdict slips themselves had the different dates as well as the different firearms, which also shows that the jury considered it separately. The prosecutor also did not spend, it was not a large focus of their closing in terms of the offenses on July 15th. So even if this court were to find that the judge abused their discretion here in terms of not severing, there wouldn't be prejudice. And I understand my time has expired. I would just quickly note that the defendant here also didn't note if there was a tactic or a right that was lost here about those charges not being severed, something like perhaps a defense being lost or anything like that. So for all of those reasons, I would think it's the defendant did not suffer prejudice in this case.
Okay, excellent arguments from both of you. More interesting case than I thought coming in, and it's submitted.
Thank you.
The case is now being recorded.
Good morning, welcome back. I am Justice Rubin. I'm joined today by Justices Kinder and Ditkoff. This sitting of the— Good morning, welcome back. One of you has your audio on. Kinder and Ditkoff.
YouTube.
If you could close that window, that would be helpful to us. I think that problem may be solved. The appeals court is hearing this argument by teleconference due to the ongoing pandemic. The rules for argument are the same as they are when we are in person, which is 15 minutes per side and no rebuttal. The next case we will hear is number 21-486, Credit Suisse Securities USA LLC versus Jonathan J. GALLI and others. And we will hear first from Attorney Bucking.
Thank you, Your Honor. Good morning. May it please the court. James Bucking, Foley Hoag for Credit Suisse. I want to begin by saying I don't know that I've ever had a case in 3 decades of practicing law where I could say that the case turns on the standard of review section of our brief, but in fact, this case does. And the key case in the standard of review section is the local 589 versus MBTA case from the SJC back in 1984. And the fundamental issue in this case is whether the arbitration panel did it or did not have the authority to award attorney's fees to the claimants in that case. And in cases where it turns on whether the arbitrators had the authority, there is no deference that's accorded to the panel. And most of the briefing in this case, back and forth between the parties, was over the standard of review, with the appellees asserting that the standard of review is the same as it is for every other case. Therefore, there's great deference, and we should tie ourselves into knots trying to figure out a way that we might salvage what the panel did, whereas we have asserted that in these kinds of cases, you do not accord deference to the panel, and instead, essentially, the burden shifts to the other side to establish this.
There are 3 arbitration agreements involved, is that right?
I'm sorry, Your Honor?
There are 3 arbitration agreements involved.
I think there's one for each of the claimants, Your Honor.
Where are they? Where in the record would I find them?
I don't have a particular site to the record on.
Are they in the record? Do we have them?
I'm not sure, Your Honor.
What did their choice of law provisions say?
The choice of law provision says.
And where would I turn to it to see it?
Your Honor, the parties, both parties, I think, agree on this point in their briefs, that the choice of law on the contract claim provides for New York law.
There's no contract claim, it's an arbitration agreement.
Well, there were underlying contract claims at issue in the arbitration.
Okay, but I'm trying to figure out the scope of what you've agreed to. And I looked, I think, in vain in the record to see what the scope of the arbitration agreement is, because I don't think I have it. Unless it's just some manual, there's a manual, but I don't know. Are the FINRA rules applicable?
Yes.
How would I know that?
Both parties cite to the rules in the briefing, Your Honor.
I understand that, but I'm trying to figure out the scope of the agreement. That's what you've told me I have the authority to do, but I don't see the agreement. And so it's hard for me to figure out what the scope is. And then if the FINRA rules apply, maybe they say something about this, but I don't see them in the record.
Your Honor,
and if there's a choice of law provision, if maybe New York and Massachusetts law are different about when attorney's fees can be awarded, and I don't know if they are, I don't know which law to apply because I don't have the agreement in front of me. I think.
Your Honor, I would put it this way. Massachusetts and New York law are identical, and we cite all of those cases that establish that. The Massachusetts decision in Beacon Towers, the SJC case, sets forth the standard in Massachusetts, and then there's the Hooper case in the New York Appeals Court, which sets forth the standard there, and they're identical. And in each case, they establish that there is a statutory prohibition on an arbitration panel awarding attorney's fees unless there is an agreement that provides otherwise. And so I would say, Your Honor, here, I don't believe that appellees have established that the agreement establishes otherwise, and that may be why you don't see it in the record.
Counselor, that assumes that the agreement didn't agree to submit the arbitratability to arbitration. Because if it does that, then we have to defer to the arbitrator's determination that the attorney's fees was arbitratable. And what I found the Employee Dispute Resolution Program Manual, and I found the submission agreements. Those are both in your appendix. The submission agreements say that they agree to submit all the claims, counterclaims, and such that are attached. And there's nothing attached in the appendix. So is there anywhere in this record, is there something else that's part of the arbitration agreement? And how will I know what was submitted with those submission agreements?
Your Honor, I believe that what the record is the entirety of the record before the arbitration panel. That is the record that went to the Superior Court, and I believe that's the record before you. So you have what the arbitration panel had. But Your Honor, could I just take issue with your statement about arbitrability? I don't think that is correct, that this turns on whether the arbitrators got to decide arbitrability. That may be true as to liability or damages questions that went to the underlying issue. I don't think it's true as to attorney's fees, because that is simply a matter of statute in Massachusetts. It's how the SJC has been.
Unless you agreed that the arbitrators would get to decide what the scope of their authority was. If you
Right.
agree to that, then the Supreme Court tells us we have to defer to that. And that's what I'm trying to figure out, because you have to be clear and unmistakable evidence of that under the US Supreme Court law. I'm trying to figure out how we can tell whether that is. Do we have enough contracts here to determine that? Or, does FINRA Rule 13200A make it arbitratable, like your friend suggests in his brief?
Well, the applicable FINRA rule speaks to attorney's fees, and what it says is that FINRA takes no position on the issue of attorney's fees. And
What
so
about arbitrability? Do the FINRA rules, your brother cites a case that says the FINRA rules give arbitrability to the arbitrator, although I don't know, I don't have the FINRA rules, and I'm not taking judicial notice of some private company's document. I don't know. I don't know where I guess I could go online and look, but I don't know what was in place when this was done. And I don't even know if you were supposed to arbitrate under those rules. I don't know anything about it.
But Your Honor, this is not a question of arbitrability. It's a question of whether the panel had the authority under Chapter 251, Section 10 to award attorney's fees.
But the panel determined it did. And so if that wasn't a question that got submitted to arbitration, then we don't have to defer to it. But if that question of whether they had the authority was something you also submitted to arbitration, then we've got to defer to it.
Well, Your Honor, yeah. I mean, I think we're there sort of. I think we're now talking about multiple stages of looking into, sort of a ship within a snow globe. I think the issue is much more straightforward than that. There is case law from the SJC that simply turns this analysis on its head, that it says clearly that under the statute, there is no right to attorney's fees unless it's affirmatively established that one of the exceptions is met. So
is a mutual request for attorney's fees a basis for awarding attorney's fees?
There's no case in Massachusetts, Your Honor, that says it does.
I agree with that. That's part of why I asked you which state's law applies.
Yes.
But you said they were the same.
They are the same as to the statutory presumption in favor of the American rule and against the awarding of attorney's
Okay,
fees.
so a mutual
That's an
request.
exception.
Let's say there's a mutual request.
I would say it this way, Your Honor. There are many New York cases that deal with this question that are informative, that both parties discussed in their brief. The question in Massachusetts is, under the Beacon Towers decision, is whether the mutual request constitutes an express agreement. Okay.
Are you asking us to hold, I didn't see this in your brief, but are you asking us to hold that a mutual request does not put attorney's fees before the arbitrator?
I am not saying either way, Your Honor. I think the question is whether what happened here constituted an express agreement. So it's conceivable there's some set of facts, I suppose, where a mutual request might be an express agreement. It would depend on the facts. I'm not going to comment on a hypothetical case where maybe it would, maybe it wouldn't.
It's not a hypothetical case. The arbitrator said that both parties requested fees in closing argument. I understand that you say that's not what you did. I'm not sure if we're allowed to, is that the kind of error of fact we're not allowed to look at?
I don't think so, Your Honor. I don't think anybody is saying we did. Even the appellees aren't saying we did. They're saying that you could change the words to.
Oh, I agree with that, but usually we don't look at arbitrators' agreements and worry about what the words are, right?
Right.
And
Your Honor,
usually the agreement is the arbitration agreement, and we can look at that. But in this case, if attorney's fees are being awarded, I gather both parties say it's because of something that happened at the arbitration. Now, let me ask you this. If we were to conclude that you had agreed by submitting a request for fees that we thought were attorney's fees, I know you say that's not, but what if we read that and say, well, what fees are they talking about? I think that's attorney's fees.
Okay.
So you said the prevailing part, we should prevail and we should get our fees. And the other side said, no, we should prevail and we should get our fees. If we think that that is sufficient to put before the arbitrator the question of attorney's fees, and then they stupidly and wrongly, they think the reason they can award fees is something you said in closing. Does that matter? Or that's a mistake of fact that we aren't allowed to get to?
So, Your Honor, I think it's important to look at the local 589 versus MBTA case, because I think this answers that question. In that case, page 411, the SJC said, in determining whether an arbitrator exceeded his authority, judicial review is independent and you do not defer. Okay, so that's the standard established 38 years ago.
And how does that answer my question? Or what my question is, if I think you submitted attorney's fees and they submitted attorney's fees, and both asked the arbitrator to award you attorney's fees, then we're done, and you did, assuming in Massachusetts, the law permits that.
I disagree, Your Honor. I think fundamentally what the case law establishes is that you decide that question, not the arbitrator. The arbitrator doesn't decide this question. The court decides this question. So it is possible, like the New York courts did in the Matza case and the Goldberg case and the other cases, you could look at the record and say, this court believes that there was an express agreement that satisfies the standard in Beacon Towers. You can do that. I don't think the record supports that. What we're saying you can't do is say, well, the arbitrator might have thought that, and even if he was dead wrong, it doesn't matter, we defer to him. The local 589 case establishes you don't defer. That is a judicial question, that reviewing the authority of the arbitrator on a question of attorney's fees is a judicial decision. This is a rare area where the court is paramount, not the arbitrator. You don't defer, you make your own decision.
So the fact that they have erroneously said the basis was closing argument, I don't defer to that. I look and try to decide, was there authority to award attorney's fees, period?
Yes.
Okay. But
yes,
I don't say, but I take it you think it would be wrong to say, well, of course you've put attorney's fees before them. You said they could hear a Mass Wage Act claim, and that has attorney's fees.
Yes.
So obviously they have some authority to grant it. Clearly they have some authority, but you say that we don't defer.
Yes, Your Honor, that's correct. In other words, I think a fair reading of the award, really the only reasonable reading of the award, is that the panel said there was no Wage Act violation. I think that puts this into the realm of a couple of appeals court cases, Conway and Kelly, which we've cited.
Counsel, I want to push back on that, because the only evidence that they didn't find under the Wage Act is that they didn't triple the damages. There's something else?
Yes, there's several other things.
There's other things? What are the other things?
Well, we cite them in our brief. The panel in its award clearly said that they're bringing a Wage Act claim, clearly said Wage Act required treble damages, Wage Act required attorney's fees. The panel did not find a Wage Act violation, rejected treble damages, did not find attorney's fees in the Wage Act, and said all other claims that are not allowed are denied. So when they say you're bringing a Wage Act claim, and all claims not allowed or denied when they don't say there's a Wage Act violation. But
can I ask you then, what is the basis for the damages if it's not the Wage Act?
A breach of contract, Your Honor. There were tort and contract claims in the case, in addition to the Wage Act.
So let me ask you this: if I don't find what you just said compelling, and I think it's unclear whether they either found Wage Act, but wrongly didn't award triple damages, or didn't find Wage Act and wrongly award attorney's fees, why isn't the result to remand it to the arbitrators to let them do one or the other, either triple the damages or or get rid of the attorney's fees.
Your Honor, there are two cases from the appeals from this court that don't do that. The Conway case and the Kelly case, which we cite, where the court says, no, there is nothing inherently inconsistent about the fact that you find that wages are owed, but there's not a Wage Act violation. There's two separate cases. And I would also point to the SJC's Boston versus Boston Police Association case. I understand that involved an arbitrator finding no excessive force, but this court said that's what the arbitrator found, and we need to just take that as it is. That's a predicate for for what comes afterwards. In that case, was a public policy decision. In this case, the predicate factual findings about whether Mr. Galli was terminated, whether he was paid or not paid wages that were due him, those are facts the arbitrators could and did decide. Whether or not there was a contract violation or a Wage Act violation are things the arbitrators could and did decide. The issue before this court is neither of those things. Those you take as you find them. The issue is, having found those things or not, is there a basis under Chapter 251, Section 10 that allows the arbitrator to have awarded attorney's fees? The reason the arbitrator cites clearly no, it's clearly no basis at all because it didn't happen, nor is there any other basis by which this court could allow attorney's fees. And I'd submit this court shouldn't allow attorney's fees on some basis this court decides. It's up to the court.
Can I ask you a question? I know your time has expired, but this is a complicated case. Does the arbitrators retain jurisdiction? Could you have, for example, asked them in a motion for reconsideration or something to correct a factual error like, but we didn't ask in closing for attorney's fees? Is there a mechanism like that rather than going through all of this multiple layers of litigation? If really it's just a mistake, is there a way to do that?
In general, I'd say the answer is no. The arbitrators are functus officio once they've issued their decision and the matter is closed. And I would submit too that there's no reason to think this was a mistake.
Well, you say it was a mistake, a factual mistake. You say you didn't ask in closing. Can I ask you one other question about your closing argument? You had counterclaims.
Yes.
Did you ask in the closing argument? Did you ask to have them that the arbitrators find in your favor?
Your Honor, no. The sole request in the closing argument was that the claims brought by the claimants be denied.
So, do you think that you abandoned your counterclaims in the closing argument? Is that how you'd articulate it?
I suppose, Your Honor, that's a fair way to articulate it. They were not pursued.
Okay. Are there, I know we're over, but it is complicated. Are there other questions to the panel? I don't see any. All right. Thank you very much for an excellent argument.
Thank you, Your Honor.
Here now from Attorney Miller.
Thank you, Your Honor. May it please the court, Robert Miller of Lax and Neville for respondents. I'll respond actually to the court's last question. The answer to that question is yes. It's FINRA Rule 13905. It provides a period of time for a party to seek correction of an award issued by a FINRA panel. I think the court's question gets to the heart of one of the issues raised by this application, which is that Credit Suisse waived. It spends a lot of time mischaracterizing the decision of the court below and almost caricaturing it as requiring Credit Suisse to affirmatively deny that it requested attorney's fees. In reality, the attorney's fees issue and governing New York law on the attorney's fees issue.
Why do you say New York law governs?
The parties agreed in their first the master share agreements that governed
where is that? Where would I find that?
I do not believe that it was submitted in the record on appeal.
Isn't it what tells us the scope of arbitration?
Actually, in this case, that too is complicated. The uniform submission agreements primarily tell the court where to look for arbitrability and the rules governing the arbitration. because the uniform submission agreements were the last agreement in time between the parties to arbitrate their dispute, and submitted the
uniform
agreement.
Submission agreement is the form that you send to the arbitrators?
It's a form that's sent to FINRA dispute resolution. As I'm sure the court knows, FINRA is the self-regulatory organization for broker-dealers and their employees, registered employees.
Sure.
The submission agreements submit all matters in controversy between the parties to arbitration pursuant to the FINRA Code of Arbitration for Industry Disputes. Both parties executed those agreements. We cited clear controlling case law, and we can certainly provide
those agreements.
more of it to the court. I believe, although I don't have a cite for you to the record that Credit Suisse submitted, I believe that the court has observed that the uniform submission agreements were filed as part of that record. I don't have.
Counsel, we do have them, but they don't really say what you just said. They say that we submit the present matter in controversy as set forth in the attached statement of claim answers and all related cross claims, counterclaims, and or third-party claims.
And it is undisputed by the parties. I'm sorry, excuse me.
And there's nothing attached to them that we.
It's undisputed by the parties that the pleadings are as set forth in the briefs. There may be some dispute now, although there was not during the arbitration, as to what the term fees means in Credit Suisse's counterclaim.
How am I supposed to figure out whether it's New York or Massachusetts law? I'm totally baffled by this.
Your Honor,
back and forth. It's New York law. So if it's New York law, why am I looking at Beacon? If it's Massachusetts law, why am I looking at whatever it is, Goldenberg? I don't understand.
I think it is undisputed between the parties that New York law applies to the attorney's fees question. It was certainly undisputed during the arbitration, because there is a choice of law provision in the master share plan, and Credit Suisse
we don't have before us.
That's correct. I don't believe that was filed. I think that the employment dispute resolution program was filed. That too contains a very broad choice of law provision that requires the application of New York law to all questions in dispute.
Counsel, that only requires that the arbitrators apply New York law. It doesn't say everything revolving around this will apply New York law. So maybe the panel would apply New York law, but that wouldn't tell us what we have to apply.
The master share plan also provides broadly that all disputes between the parties will be governed by New York law.
Does a mutual request for attorney's fees put attorney's fees before the arbitrator?
Yes, it does.
Why do you say that? It looks to me, when I look at the New York cases, like if the arbitration rules say it does, those cases look like they're all about AAA arbitration, the Warner Brothers case, and there's another one. There's a case subsequent to this hearing, a case called SELVIN or something, that from the appellate division, that indicates that it has to do with whether the rules of the arbitrator say that. And we don't have the FINRA rules before us, so I have no idea.
Well, let me take that in two parts. First, and we cite this, I believe, in our opposition brief, but if not, on this question, the case Cantor Fitzgerald v. Pritchard, which is a First Department decision 107 AD 3D 476. That's a FINRA arbitration. It's applying the same standard under New York law, that a mutual request for attorney's fees forms a binding agreement for the purposes of New York's own statute governing awards of attorney's fees in arbitration, which was the statute that was litigated to the panel and is a statute in which all these cases are brought. I would also say,
do you agree there's no Massachusetts law on this question?
I believe that the Massachusetts law, and this is, as the panel or as the court correctly pointed out, the Supreme Court requires the Massachusetts courts to apply New York law to this question of the submission of attorney's fees to the panel. I am not aware of Massachusetts cases on this point. Neither side has litigated this point under Massachusetts law. The parties, it's undisputed that New York law applies. The second point,
undisputed. I think your brother disputes it. I'd have to look at the brief again. but I don't think it's undisputed that New York law applies.
Well, I believe what is disputed is what law is going to be applied to the vacature standard. And I will say there, I agree with my brother that under the vacature standard in Massachusetts and New York, the outcome in this case is identical. I think both states would apply the same substantive law that was applied by the arbitrators to the question of whether a request for attorney's fees was before the panel. I think both states would find, as the court immediately pointed out to opposing counsel, that controlling cases, and we cite some in our brief, but there's also, of course, the foundational Supreme Court case, Master Bueno v. Shearson. There's Payne Weber in the Second Circuit. Have held that under the FINRA rules, where an arbitration is governed by the FINRA rules, arbitrability is a question for the arbitrator.
I don't have the FINRA rules before me, so I'm going to have a pretty hard time deciding what they say or compel. And I don't know if they've been changed. I don't know when they're changed. I don't know what was applicable then. And I'm not going to Google it, right? So
we entirely understand, Your Honor. We think, given that we entirely stand by the decision of the trial court, and it is Credit Suisse that brought this application and was challenging the trial court's decision, it was Credit Suisse's burden. With the leave of the court, we'd be happy to supplement the record.
No, I have no interest in. I don't know what was before the trial court even. Let me ask. Well, I'm sorry. Go ahead.
Counselor, you just said the Second Circuit says that under the FINRA rules, the arbitratability is arbitratable. But the only case, maybe I missed it, that I saw you citing an unpublished district court case, and I did some Second Circuit research, and Metro Life Insurance versus Bussack seems to say the exact opposite. So what Second Circuit case tells me that anything applying FINRA, the arbitratability is arbitratable?
It's Payne Weber v. Bibek, BYBEK, 81 F3D 1193. That was applying the predecessor to the FINRA rules, NASD. It's been applied in Murray v. UBS, which is a district court decision, January 27, 2014, that we cite in our brief at page 41. And I can also give the panel a more recent decision, or excuse me, a contemporary decision, BAME v. Group Agent Securities, which is SDNY 2011. And then it is also the law that has been adopted by New York State.
You have a site for BAME?
Oh, I'm sorry. It's 2011 Westlaw 29.
So it's unpublished.
46718.
Okay, so that's an unpublished district court decision.
And then not an unpublished district court opinion is the Court of Appeals decision in Smith Barney Shearson v. Sakharov, 689 NE2D 884.
Hold on, a little slower. 689
NE2D.
Yep.
Northeast 2nd 884 at page 888.
Do you agree that the arbitrators were incorrect in their factual statement that in the closing argument, Credit Suisse requested attorney's fees?
Absolutely not. I think what has gone on here has been a confusion of the record by Credit Suisse. As the court knows, and this is in the record, the issue of attorney's fees had already been raised to the panel. The issue of mutual request and our request and Credit Suisse's request was being addressed by counsel in a colloquy at the time of closing arguments. Mr. Pegno, who is, for whatever reason, not representing Credit Suisse on this appeal, but remains counsel for Credit Suisse in these cases, he challenged the legal basis to award attorney's fees.
I fully agree with that, but he didn't affirmatively ask for attorney's fees. I agree that he didn't say there's no basis, or that when he said there was no basis for attorney's fees, he meant for your attorney's fees. I don't read him to be saying, and nor may you award us attorney's fees should you decide to do that. I don't see that. And then he does go on and he says, well, if you were to think we were wrong and to consider attorney's fees, they're inadequately supported. Okay, and so that might even be some kind of acknowledgement that what he's saying isn't, this is completely beyond the pale in some way. But that's not a request by him for attorney's fees for Credit Suisse. And I don't see that in the closing. So to me, that seems like an error. I'm not saying reverse that kind of error, but it seems like an error.
He promises that Mr. Komarski, his colleague, will address the issue. Mr. Komarski did not. I think, I agree that it's not reversible. I also don't think it's for the court. It is the court's burden to look into the record and explain away the different components of the award in that way. But if the court were to do that.
If the basis for attorney's fees is only available to us in the record, which seems odd to me, but I'd never heard of this mutual request idea, but there it is. We do have to look at some of the stuff that went on before the arbitrator to figure out if there's a mutual request.
What I don't think the court has to do is look into the minds of the arbitrators to determine what it is they were trying to get across in the award. But if the court were to examine that question, I think it is because, as is in the record, I believe in our closing presentation, the law had been submitted to the arbitrator on mutual requests for attorney's fees and on the issue of repudiation and withdrawal of attorney's fees. I think that the panel determined that as of closing arguments, no withdrawal had been made by Credit Suisse. It was requested in the initial pleadings. It's clear in the initial pleadings it had not been repudiated.
Yeah,
and the issue
they definitely didn't do that. They don't say that anywhere in their award. They just say it was argued in the closing argument.
They say that a request was made in the closing argument. I'm giving an interpretation of the award that would make it non-factually erroneous. But I agree with the court primarily that is not a question for the court to reach. The arbitrability of attorney fees.
I said to your brother, it's like an error of fact, but it's a little different if in fact this is the place where the alleged agreement took place, and if we're supposed to de novo review the scope of an agreement between you, and what we're supposed to be looking at is the closing argument, maybe we don't find an agreement there.
We certainly do not agree that the court's confined to the record of the closing argument or to the face of the award. Massachusetts courts, including Beacon Tower, in fact, most of Beacon Tower's discussion of the AAA rules is devoted to a basis for the award that was raised by the petitioner, not a basis that appeared in the award. In fact, though Credit Suisse repeatedly says that the court engaged in a painstaking analysis and found and vacated the arbitrator's determination that there was an agreement for attorney's fees, the arbitrators in that case expressly held, it's quoted in the decision Beacon Towers, expressly held that there was no agreement and based their authority entirely on a statutory authorization that the Supreme Judicial Court found, not that it reviewed it and found that it didn't meet the conditions of statute, but found that the statute did not apply in arbitration, only applied in court. That's what actually happened in Beacon Towers. But Beacon Towers devotes several pages to analyzing the AAA rules because petitioner argued that even if the AAA panel held that there was no agreement that did satisfy the AAA rules, another AAA rule provided sufficient basis. The court analyzed that rule because the court is free to look for any colorable justification for the finding of the arbitrators. And I think this...
Your time has expired, but yeah, go ahead.
No, you can go.
No, I don't have a question.
We excuse him. Okay, so I saw that you submitted an attorney's fees affidavit at the time of close. It looked to me like the employer didn't. Is that right?
To my recollection, I don't believe Credit Suisse submitted an affidavit.
You've also requested appellate attorney's fees, and I didn't really get the basis for it. Could you explain?
Again, we contend that the vacature issue has been raised on both the mutual request for attorney's fees and the Wage Act. And we believe it's the law in this state that where the confirmation or vacature action on attorney's fees is predicated on the same issue that was submitted below, attorney's fees are awardable by the court. And if it's awardable by the court below, it's awardable by the appellate court. And if I could just
Wait,
add
I'm sorry, on what ground? On grounds of frivolity, or I don't understand.
On grounds that, and we can get the citation, I don't have it right in front of me, but on the grounds that if attorney's fees were not allowable on appeal, it would undermine the whole purpose of a mandatory attorney's fees provision, such as the one in the Massachusetts Wage Act.
Oh, I see. So it's the Wage Act that you're saying.
It's the Wage Act, and I think the Wage Act, which has not been addressed here, but the Wage Act provides a clear basis. I would also say that there is no de novo review under any standard. I understand I'm out of time, but just the last point on this. The way that Credit Suisse characterizes Beacon Tower as applying more exacting.
We understand your argument from your
Understood
on that point. Are there other?
I did have just one clarifying question on one of your last points, Attorney Miller. If we reach this question of mutual request, is it your position that as a matter of law, we may look to the counterclaims submitted by Credit Suisse and make a finding on the basis of request in those counterclaims?
If the court were to reach that arbitrability question, yes, it is our contention that the court can look to that to find that that basis was available to the panel to confer authority. We do believe that it was then for the panel to make a determination as to whether a mutual request would be enforced and attorney's fees would be awarded.
Okay, thank you very much. Complicated and interesting question. Excellent arguments from both of you. The case is submitted.
Thank you.
Case is now being recorded.
Welcome back. Our appeals court session continues. I am Justice Rubin, and I'm joined today by Justices Kinder and Ditkoff. The next case we will hear, the rules for argument when we hear argument by video conference as we are today due to the ongoing pandemic are the same as in the courtroom, 15 minutes per side, and there is no rebuttal. And the next case we'll hear is number 21-543, K.L.Z versus DV. I will remind the parties that this is a partially impounded case and you should adhere to the impoundment order. And we will hear first from Attorney Penariello.
Good morning, Your Honors, and may it please the court. Natalie Penariello of Foley Hoag for Plaintiff Appellant K.L.Z.
Your microphone, I don't know where your microphone is, but we're having a little bit of a hard time hearing your audio. If you can bring it a little closer to you somehow, that might be helpful.
Is this better?
A little bit.
I'll do my best to very much project.
Okay, thank you.
Your Honors, K.L.Z is a victim of sexual assault who sought and received a harassment prevention order in 2019. At the extension hearing approximately 1 year later, K.L.Z was required to relitigate the assault committed upon her. Relitigation of the underlying assault was plainly at odds with the Supreme Judicial Court's decision in IMLE v. SELVIN. IMLE makes clear that a restrained party may not challenge the evidence underlying the initial order at an extension hearing. But that is precisely what the defendant did. IMLE further instructs that the court may not second guess the basis for the initial order, nor may the court terminating an existing order on its own motion. Again,
Counsel, isn't the evidence underlying the initial order at least relevant in that it relates to the relates to their ongoing relationship and your client's fear and whether or not that fear was reasonable at the time?
Yes, Your Honor. The nature and the basis for the underlying order and the nature of the underlying incident are relevant to the court's determination of whether or not to extend the order. However, here, it wasn't just consideration of the underlying incident or the nature or basis for it. It was something much, much more. Essentially, the defendant improperly set out to prove that the underlying incident of sexual assault was consensual, meaning that it was no sexual assault at all. This flew in the face of the court's finding at the 2019 hearing that the defendant caused the plaintiff to involuntarily engage in sexual relations. The defendant's testimony on direct occupies 20 pages of the hearing transcript and only went to incidents and communications that predated the 2019 initial hearing. And the defendant introduced the very same exhibits, the 2019 email communications that he introduced at the initial hearing.
Well, why wouldn't that evidence, at least to some degree, be relevant to your client's fear at the time of the extension request?
It may well have been relevant, and I don't think our argument is not that it was necessarily improperly admitted so much as it was improperly considered to second guess the basis for the initial order. During his closing, defense counsel repeatedly argued that the underlying incident of sexual assault didn't occur. For example, there are quotes at RA 174, Your Honor, the objective evidence that was introduced in this hearing does not support the plaintiff's account of what occurred. At RA 175, if you look at the events that followed from that April of 2019, I think there are several events and several facts that cast doubt on the plaintiff's account of that evening being the April 2019 evening that the sexual assault occurred. And at RA 179, Your Honor, I think the evidence is clear based on the timeline of events and all.
Counsel, we don't get to review your friend's closing argument. We only get to review what the judge ruled. So, how do we determine that the judge made the error that you're saying your friend made?
Yes, Your Honor. When the court ultimately made her ruling, she stated, based on my determination of all of the events back in 2019 and after, I do not see a sufficient legal basis for this type of order. So I'm terminating the order effective today, effective now. That the court was making any determination of the events back in 2019 was improper. And I think defense counsel's statements during closing argument sort of bring light to what was in the judge's mind at the time that she made that ruling and terminated the order. And I would add that terminating the order wasn't even on the table. IMLE instructs that the court may not on its own motion terminate a existing order at an extension hearing. And
Counsel,
that's go ahead.
What relief can we give you as to the termination, the premature termination?
Yes, Your Honor. This was an issue that this court decided in a case called Mitchell v. Mitchell, which is at 62 Mass App Court 769, where the underlying, where the court vacated erroneously, this court found an existing order. And the relief that was issued there was vacating the order of termination, which, and I'm happy to get to this, has sort of consequences beyond just the termination itself, and offered the plaintiff the opportunity within 30 days of this court's decision to apply for a new order, and ordered that at that hearing, if the plaintiff were to take advantage of the opportunity to apply for a new order, the standard of continued need would be the standard that the court should apply, as opposed to what would typically be the standard at an initial hearing.
And that's the relief you seek.
We seek vacating the termination and remanding to the court for further proceedings. However, if this court thinks that
okay, so if we do that, further proceedings, there's nothing in place right now, though, right? Even if we vacate, it doesn't, because the thing we are vacating an order about expired of its own force back when, there'd be nothing in place. So it's effectively the same thing, but you think it's a mere remand, and then there gets to be a new hearing on, is there continued need?
That's correct, Your Honor.
Can I ask you something about that? At the termination hearing, Your client testified, I just like the harassment prevention order extended until June of 2020, and the transcriber's written sick there, which I assume, I mean, it's got to be wrong because obviously the hearing happened after that. What is the real date?
June 2021, she graduated from the medical school.
All right, so we're past June 2021. So is there, regardless of what should have happened between September 2020 and June 2021, is there a basis for the order continuing if we do remand it at this point?
Well, Your Honor, it's difficult to answer that question on this record, considering there's nothing going to, the plaintiff's whereabouts now or what was happening after June of 2021. But I would note that in June of 2021, upon her graduation, she would have been entitled, even though she only sought the extension of the order through that date, she still would have been entitled to seek a further extension at that point in time. So
I guess for mootness purposes, I'd at least like your representation that you feel you have a good faith basis to say there's a continued need today for this order.
For mootness purposes, I would again point the court to Mitchell v. Mitchell, where the court, where this court ruled that where an order is vacated, the case is not moot simply by virtue of the fact that the order would have expired several years prior. In fact, in Mitchell, the order would have expired, I believe, in 2002 or 2003, and this court did not make its decision until 2005. And yet,
well, the fact that they don't, it wouldn't simply have expired. I mean, I think I understand your point to be, even though she only asked through June of 2021 or whatever it was,
yeah,
the way these orders work, she would have had a right to come back in, right? All the judge could have done is said, well, this will expire on such and such day, and if you want to extend it, come that day. And so that can't be mooted. So the whole thing doesn't become moot because it's not like all she was asking for was something that ended and the date past which it ended is gone and like that. There was some continuing right that she would have had this been handled in what you're describing as the proper way.
That's exactly correct, Your Honor. And also, the order of termination, which is at RA 212, was accompanied by a further order that all of the records of the protective order be destroyed by law enforcement. That is a statutory requirement under 258E Section 9. And so I would further take the position.
Wait, I don't understand that. I thought that, oh, by law enforcement. There is this registry though, right? There's some kind of a domestic violence registry that a previous 258A is always in, isn't it?
That's correct, Your Honor.
Okay.
There is a separate registry. However, the plaintiff was otherwise entitled to not have law enforcement destroy the other evidence of the order or the other.
What is the other meaning? The copies of the order demonstrating that he had been served or whatever? What exactly was ordered destroyed? I'm not aware of this.
Looking at the.
Well, actually, let me just short circuit this. You're not asking that I mean, I don't know what you could do about that, assuming they followed the order. You're not asking that we ask the court below to circulate to law enforcement something, are you, or are you?
No, Your Honor. I'm just making the point that the order of termination had other consequences beyond the termination itself that gives the plaintiff.
And would that order of destruction, is that inherent in an expiring order? That is, whenever it expired, is that part of it?
No, Your Honor. It's if the order expires on its own terms, there's no statutory requirement that the law enforcement destroy the evidence of the orders or records of the orders. It's only where it is affirmatively vacated or terminated.
Interesting.
Counsel, can I take you back to the judge's findings for just a moment?
Absolutely, Your Honor.
Granted, they were not detailed and perhaps somewhat vague, but I didn't understand them to be adopting your adversary's position as to what did and didn't happen in support of the first order. The judge referenced credibility and what has happened since then. So help me understand what the judge found that you think was error.
Yes, Your Honor. By virtue of the fact that the judge terminated the existing order and said, I do not find a sufficient legal basis for an order of this kind. I don't have the language directly in front of me, but can find it in just a minute. But that what was terminated wasn't something in the future, wasn't based on a showing of continued need, but what was already in place, which I think, and I represent, suggests that she was second guessing the underlying basis.
So by that, do you mean that if the judge had said the order will terminate at 4 o'clock today, which was what was scheduled, instead of immediately, we would not be here on appeal?
Well, we might be here on appeal on a different issue, which would be whether or not the judge abused her discretion in not extending the order. But what we're now examining is whether it was an error of law or to second guess the underlying incident and to question the validity of the initial order.
Well, then just going back to the judge's findings, it's not clear to me why you're suggesting she abused her discretion given the findings as they exist.
Plaintiff's position isn't necessarily that the court abused its discretion so much as it did not apply the proper legal standard in examining an extension or in deciding a request for an extension. It's not the same showing language or standard that applies where a plaintiff seeks an order for reasonable fear of imminent harm. It's something else, where the underlying order issued for past physical or sexual abuse, the question is whether the plaintiff remains reasonably in fear. And that was, go ahead.
But you agree that the evidence the judge heard was in fact relevant to that question.
Relevant to the question, however, was used for the improper purpose of questioning whether the sexual assault that the court in 2019 found had occurred actually had occurred. Are there any more questions? Thank you.
I see no further questions. Thank you very much. Excellent argument. We will hear now from you, Attorney Griffiths.
Thank you, Your Honor. Your Honor, the focus of my argument today is that it was permissible for the judge to take testimony regarding the entirety of the party's history and to consider all of the circumstances of the party's past in determining whether the plaintiff's fear of harassment or abuse was justified.
You agree that the question before the judge, the only question properly before the judge, was does the plaintiff remain reasonably in fear?
I think that is the proper question. Yes.
Okay,
yes, Your Honor.
so if I agree with you that the judge can look at anything relevant to that, including what happened originally, everything since, anything. But the judge says, I don't think this order should have issued. How can we say that the judge properly applied the is she still in fear standard rather than simply saying I'm not going to extend this because it shouldn't have been issued in the first place?
I think what the judge said is that I don't find a sufficient legal basis for the extension of the order.
And then said,
not what the judge said.
I do not see a sufficient legal basis for this type of an order. And I am terminating it.
Right, but I think
surely we shouldn't be pretending that a new judge walked in the door after the first sentence and totally separately did the second sentence, right?
No, but I do think we have to look at all of the judge's findings. And obviously these are findings that are being made sort of in the moment. And I do think what she was indicating there was that based on her consideration of all of the circumstances, that she did not feel it was required that she extend the order any further beyond when it was, beyond the date of the hearing. that she was taking into account all of the circumstances as
Okay,
is
but
proper.
all she's allowed to do, she's not allowed to conclude. I mean, your sister says that it's involuntary sexual relations, and I don't think, for some reason, you haven't quite contested that. I thought that the basis of the order was a finding of sexual assault on a person over 14. That's which is one of the listed bases of a harassment finding. And the reason I think that is that at the original hearing, the judge said, I see that there's a prosecutor here in the audience or police or somebody, and I note that the standard is preponderance here, not beyond a reasonable doubt. So I take it that it wasn't, I don't know if this counts as involuntary sexual relations, but it sounds like the original judge found a violation of one of the enumerated statutes. And now the only question is fear. And if the judge in the second hearing doesn't say, I don't find that she's reasonably in fear. If the judge finds, I don't find there was a sexual assault, this doesn't seem like the kind of case it's supposed to be at 250-80 at all, hasn't the judge applied the wrong standard?
I don't think that's what the judge found in this case. I don't think the judge found that there wasn't a sexual assault or that there wasn't.
Then why did the judge terminate the order?
I think what the judge was doing, I think inartfully at this point was, I think what she was concluding was that there should not be an extension of the order beyond.
No, she terminated it. She said explicitly, I don't find this type of order should go on. And in an act for which there was no notice to the other party, she terminated it. I understand it was going to expire in 6 hours anyway, but she apparently felt strongly enough that this should never have ordered, that she terminated it right then and there. I mean, I don't know what the basis for termination would be, except thinking it shouldn't have issued in the first place.
I think the basis for her decision to terminate the order was her conclusion that there was not a sufficient reasonable basis to conclude that the plaintiff had sufficient reasonable fear of the defendant at that time. And
well, I don't know. Is that why did she vacate it? There was a 1-year order in place. It expired at 4 o'clock. Why would you act at 10:35 unless she meant what she said, which is there is no legal basis for such a type of order?
I don't believe she vacated the order. She didn't say that the order was void ab initio or that she was finding that the order shouldn't have issued in the first place. What she was doing was effectively ending the order at 10:35 as opposed to 4 o'clock that day.
Why? I've never heard of that in an extension hearing. Have you?
I'm sorry, Your Honor.
I've never seen that at an extension hearing before, where the judge says, not only am I not extending it, it will expire at 4 o'clock. I'm lifting it right now. Have you ever seen that? It's odd.
I have not seen it before, no, Your Honor. But I do think
Counselor, what about the fact that the judge says, based on my determination of all of the events back in 2019, isn't that stating that they were determining whether the events back in April and May of 2019 happened?
Well, I think what she's doing there is looking at the totality of the circumstance of the parties' relationship, which is what IMLE instructs her to do.
Mr. Griffiths, I hear you on that point, but as I read your argument, it sounded like much of it was directed at the victim's credibility, suggesting to the judge that what she said happened initially did not happen.
Well, I think much of my argument was directed at trying to give the court a fuller picture of the entirety of the relationship and all of the circumstances that existed between the two parties. And
Counsel, you started your argument by saying the evidence does not support her claim that Switch and defendant committed an act that constituted indecent assault and battery. I mean, that's how you started your argument.
Right, but
I guess asking the judge to reconsider whether the order should have issued in the first place.
But I guess my point in making that statement was that it's clear that judges have wide discretion to look at all of the evidence, or to consider any evidence that they believe is proper, and that what what is permissible during a 258E hearing is what is fair to both parties, right? And I think what the judge is required to do is to evaluate all of the circumstances and all of the testimony, including the testimony that she allowed from the plaintiff and from the defendant as well.
Well, but let me ask you this. This is actually a weird, this is complicated. Of course, your client didn't testify at the original hearing and there was no appeal. So that order went into place, the 1-year order. I'm not sure how do I put this? Let's say the reason you think, or your client thinks, the plaintiff is not in fear is because she was never in fear because this didn't happen. What are you allowed to argue to the judge? That is, there has been a definitive finding that's res judicata of harassment. In this case, I think that there was an indecent assault and battery by preponderance of the evidence, and that is not revisitable. So what do you think you're allowed to do with a dispute about the underlying facts at an extension hearing?
I think at that point, I'm trying to, and I apologize, I want to.
Well, I don't know what the answer to this is. This seems like an almost metaphysical question. Do you know what I mean? I understand that it is your client's position that what happened here was not a sexual assault, but something else. I get that.
So I guess the question, right, always I think comes back to whether or not there is a reasonable fear, right, which I think has to be based on an objective look at all of the facts and circumstances that a judge is allowed to consider. And the judge has to make an objective determination whether, based on all of those facts, whether or not there is a reasonable fear at that point. And I think that's what, that's what I was driving at. Again, perhaps inartfully, but that's what I was driving at during the course of the hearing, was that if you look at all of the circumstances surrounding their relationship, such as it was, that I think that a reasonable fact finder would find that there was not a rational fear that required an abuse prevention order or a harassment prevention order to continue at that point.
Do you agree that if the judge had said more clearly, I find that no assault occurred, and therefore there is no basis for the plaintiff to be in fear, and I find she is not in fear, would we have to reverse that?
I mean, I think at that point, you probably are running afoul of IMLE's, instructions that you can't, revisit findings that were previously entered. But again, I don't think that's what happened here. And I don't think the record is sufficient to find that's what happened here, because I do think what the judge was looking at was the totality of the circumstances, including everything that had happened after the order was initially entered, and the course of the relatively brief and unremarkable interactions that the two parties had had since the order had entered. Don't know if there are any other questions, but I would ask, at this point, I do think it's appropriate to find that the judge did not abuse her discretion in allowing the defendant to testify, and that basically the current status quo will be allowed to stand at this point.
Okay, I see no further questions. Excellent arguments from both of you and well briefed. Thank you very much. The case is submitted.
case is now being recorded.
Good afternoon. Welcome back to the Appeals Court. I am Justice Rubin. I am joined today by my colleagues, Justice Kinder and Justice Ditkoff. The final case we'll be hearing in today's sitting is number 21-220, Department of Children and Families and Another versus Mother. I remind the counsel that this is an impounded case, and so names shouldn't be used, but mother, older child, younger child, something like that would be preferable. And of course, you should be careful to adhere to the impoundment order, whatever its scope is. Arguments which we hear by video conference, which we're doing today due to the ongoing pandemic, are under the same rules we have in person, which is 15 minutes per side. If you divide your time, you have to let us know in advance. And my understanding is that the appellants will be dividing their time 7.5 minutes each, and the appellees will be 10 minutes for the department and 5 minutes for the younger child. With that, I gather we will hear first from Attorney Cohen. Oh, do we have your audio?
Hello?
Yes, excellent.
Shall I begin?
Please.
May it please the court, David Cohen on behalf of the appellant mother. This court should vacate the termination of parental rights decree and remand the case for a new trial because, one, there was not here the required clear and convincing evidence of current parental unfitness, and even if there was not clear and convincing evidence that it was in the best interests of children to terminate mother's parental rights. And two, there was overreach here on findings of fact and conclusions of law and inadequate analysis by the court that should cause the court to question the judgment. If I may just...
No, go ahead, please. I don't mean to interrupt.
If I might just quickly point out, the record shows mother is a caring, attentive parent and resilient person with a positive attitude. I'll briefly point to DCF itself acknowledging this in 2017 in Exhibit Appendix 232. Mother is a very caring parent when not in emotional distress due to mental health issues. And we'll more on that shortly. However, she is good at making arrangements for the care of her child in these situations.
Okay, so this is slightly complicated. Your friend argues that that is counsel for the older child, that there was inadequate attention paid to the possibility that the mother could parent one child without the other present.
Correct.
The mother's position is that both, with respect to both children, the finding of unfitness and the termination should be reversed. I'll just tell you, I'm inclined to find the findings thin, but there is a stipulation of unfitness by the mother on, I think it's May 24, 2019, that is, in some sense, I think, sort of the starting point here, although I don't see anywhere in the record where it's explained what the nature of that unfitness was, so that one might be able to tell whether it continues unabated or what. Let me also say, I've with respect to the youngest child, and I'll ask this of your colleague representing the youngest child as well, there are, I guess I'll call them sort of flags out there. Oh, the child is on the spectrum. And this presented certain difficulties, although all we hear is a handful, but we don't have the usual types of descriptions of diagnoses and issues, so that findings that, for example, mother is not going to be able to meet the needs of that child, they don't seem to be in here. But again, I don't really know why. I don't know why there was a stipulation of unfitness. So maybe you can address that.
I'm not sure the record shows why there's a stipulation on fitness. Of course, the issue is clear and convincing evidence of unfitness at trial 6 months later. And we know that in these cases, parents sometimes understandably get discouraged. I mean, mother had done services here for a good part of the first year and a half, from the parenting group in May of 2018. She completed a psychological evaluation in September 2018. She completed domestic violence group in October 2018. She was doing the visits for 2 years. So I don't know, she was making progress, Your Honor. I think perhaps uneven progress, but she had ended her past relationships with problematic boyfriends. She was looking for work. She had cleared up just recently, that's in the transcript, she had really only two things on her Corey, both null prost, and she was in the process of clearing them up so she could get reemployed as a certified nursing assistant. So there are all those things. So I don't think the record tells us exactly why she stipulated, but the issue was at trial. She was continuing with therapy and she had gotten back on her prescribed medications as a trial. Switching, I think, to your question about essentially the autism diagnosis for the younger child, the boy. That happened 1 or 2 months before trial. After, the child had, basically reached the terrible twos, was getting mobile, and DCF had returned visits to their direct supervision. They had been going on under that supervision and then were under contract all during that time for 1.5 years. Notes, nothing about safety concerns. I can, point you to the whole record, transcripts 35 to 53, exhibit appendix 21 was the court investigator report just a couple months before that May stipulation you just mentioned. So it's all, mother gets an autism diagnosis, and we're a month or two before trial, and there were a few things pointed out about mother could do better at supervising this child.
Well, there was safety concerns that strike me as genuine at visits, although it's only for a couple months.
And mother, the idea that mother admitted that she couldn't take care of the children or to take care of that child is incorrect. She basically said she was very concerned now that the child had an autism diagnosis that she would be able to take care of the child. I mean, how did the department help the mother to get through those issues? There were a few instructions, as you say, at these visits at the very end, right before trial. So there really wasn't time. And the idea that this is somehow sufficient to show clear and convincing evidence on fitness is simply not supportable. I think I've already touched on domestic violence. In many ways, that's a success story here. Mother did the service and successfully removed herself from an environment of domestic violence. That's adoption of a MELDA. There was nothing on her record, no police reports, nothing on the record that said she, that was tended to be the area where mother had some mental health challenges that maybe got potentially too much when she was around these violent boyfriends who were who were the fathers of her children. She ended those relationships. The housing issue, that's also kind of not enough. She had adequate housing from 2012 to 2017 until DCF removed both children from her. I mean, this is a mother who is poor and who utilized public benefits and part-time work for a long period of time to have publicly assisted shelter housing. She had that for years. She didn't have housing because DCF removed the children. All right, I think I will, because I can see my time is jumping down, I will speak briefly to the mental health issue where there are adoption of Darlene tells us that only where it is shown that such deficiencies, mental health challenges, they can be used to protect, they can be used to find unfitness if they impair the ability to protect and care for the child, and only then. And again, mother cared for her daughter for 7 years here, broadly, successfully, well-fed, medically up-to-date, sheltered, attended school, did well. Where is the clear and convincing evidence here that mother's failure to take psychological medications, which her psychiatrist recommended, consistently, or that she failed to attend therapy more faithfully than 75% of the time, made her unable to satisfactorily care for the children?
Counselor, the docket sheet says your notice of appeal was filed on June 8th, which would be 9 days late. Can you give me any enlightenment about that?
I will confess to have not had the opportunity to double check that before coming on today, Your Honor. I believe it was during the COVID pandemic, although 2019 doesn't sound quite right. So if I may check on that for the court following.
No, it was 2020. You might be right about the COVID delay.
Oh, that's right. It was 2020 when the order came out. So I think that's the case, Your Honor.
That might be right.
Okay, thank you very much. We will hear next from Attorney Hopple.
Good afternoon, members of the panel. May it please the court. My name is Natalie Hopple, and I represent the female child in this appeal. Your Honors, from my client's perspective, the lower court's judgment does not adequately explain why my client cannot return home to her mother's care. A child-specific analysis contemplates a judgment that is not only written for the benefit of parents, but for each child who is involved in child welfare proceedings. In other words, when my client turns 18 and comes to my office to read this judgment, I am not confident she would read this judgment and understand exactly why she was not permitted to return home to her mother. The lower court's judgment does not tie a constellation of facts to a conclusion that mother's purported unfitness existed or was likely to continue into the indefinite future at the time of trial. This is because the lower court erred in this case in 3 significant ways. First, the lower court erroneously concluded mother could not separately parent my client. I would direct the court to conclusion of law number 10. In that conclusion of law, the court pushes the children together and combines them in terms of concluding that mother could not parent both children together. And that's found on RA 33. Turning to the findings previously in which the court discusses parent-child visits, and that's found on RA 29, the court ultimately concluded that mother was able to adequately parent my client and was more adept at parenting my client than her younger brother. Second, the lower court failed to establish a nexus exists between mother's alleged parenting deficiencies and her purported inability to parent my client. Your Honors, the concept of nexus requires that the findings are tethered to the conclusions of law. It's not enough to recite mother's conditions. Rather, the court must show how mother's conditions affect her inability or purported inability to parent my client. There is a strong argument, Your Honors, that judges do struggle to make best interest determinations. Here, Your Honors, there was an evaluation that was conducted that's found at EA 284. I'm sorry, excuse me, Your Honors. There was a family action plan found at EA 284 in which DCF required mother to have a parenting or psychological evaluation conducted. That evaluation was obtained and presented to the court at EA 341. At the time of trial, the court questioned the validity of the parenting agreement. What was available to the court at that point in time if the evaluation was not sufficient, given that the family action plan was relatively vague in terms of what kind of evaluation was necessary, the court could have at that point in time declined to terminate as to my client, considering that mother had a more adept ability to parent her oldest child. Your Honor.
Counsel, I didn't see any sibling visitation in this. Is that right, or were they visiting together?
Your Honors, my understanding is that the sibling visitation was conducted concurrently. The children were seeing each other during parenting time with mother, but there was no separate sibling visitation that had been conducted during the course of the children having been removed from mother, or at least it's not indicated as part of the record. And if I am able to find it, I can supplement that information. I think another issue is whether or not sibling visitation or visitation with the children was conducted separately for both of these children. If mother was struggling to parent one child, it would be indicative, or it would be useful for DCF to conduct a separate parenting time between mother and my client to determine whether mother could potentially resume parental responsibility for my client. That did not occur to the best of my knowledge based upon the record. Your Honor, turning to the next issue with the judgment, the lower court erroneously and ambiguously applied lesser quantums of proof. Your Honors, the idea of reliability is not predicated on perfection in a judgment, but there is a degree of certainty that a judgment needs to meet in order for it to stand review. Here, the court first erroneously stated a lesser quantum of proof in conclusion of law number 2 found at RA 31, in which the court indicated that the department had proven by at least a fair preponderance of the evidence. Turning to the next conclusion of law found at RA 31, the court then stated that the department met its burden of proof, which is ambiguous. Turning next to conclusion of law 29, the court then stated that petitioner sustained its burden of proving by clear and convincing evidence that mother and father are currently unfit to further the welfare of the children. The idea, Your Honor, that both the mother and father are both, or the mothers and fathers are referenced in the judgment is somewhat confusing. Both of the father's parental rights were terminated on May 24th, 2019, and that's found at RA 19. So it does not make sense that the judgment at the trial involving mother's parental rights would reference both mother and father. It also does not make sense to the extent that there are two separate fathers for both children in this case. So it is not clear as to what the court intended when it set forth conclusion of law 29. Your Honors, given the significance of due process rights that are at stake in termination cases, burdens of proof cannot simply be deemed clerical errors. A misapplication of a burden of proof rises to the level of a due process violation because it creates a significant analytical gap that calls into question the reliability of this adjudication. Even if the court eventually used the correct standard of proof, the initial misuse and ambiguity of a lesser quantum of proof shows that the department did not necessarily meet its burden of proof in this case. Your Honor, if the court has no questions, I'm happy to rest.
Do you have some kind of motion pending before the trial court now? Is that motion for redetermination pending?
Your Honor, that motion for redetermination was filed last Friday. It is currently pending. The department has objected to it. For all intents and purposes, I do believe that we intend to move forward with that motion.
Okay. I see no other questions. Thank you.
You'll let us know promptly if anything happens, right?
Yes, Your Honors.
Okay, we will hear next from Attorney Kernan.
Thank you. May it please the court. Jennifer Kernan for the Department of Children and Families. The department is asking this court to affirm the judgment and decrees of the lower court because there is clear and convincing evidence that supports the conclusion that mother is unfit and to parent both children, as well as the conclusion that termination is in the best interests of both children. First, addressing unfitness. I think the biggest factor here is that mother is still struggling to properly address her mental health. She had been seeing a therapist more consistently in the 6 months.
What is the nexus between that? Your colleagues here argued that there's no showing of a nexus between that and unfitness. What is the parental shortcoming that is the result of the untreated or partially treated or still ongoing mental health issue?
The nexus between the partially treated or untreated mental health issue is mother's ability to properly supervise and safely parent the children. And to support that nexus, we can look to the oldest child's, the daughter's life with mother before the removal. Mother has testified, and there's evidence in the record, and as well, I believe it's acknowledged in the findings, that when mother is suffering from the severe symptoms of depression, she is sleepy, she is late to appointments, she loses interest in things. So we have evidence, and the findings acknowledge that, of what it is that mother experiences when she is experiencing the symptoms of severe depression. We also have her testimony that when she is not on medication, she experiences these severe symptoms. And the record indicates that there have been a number of times where the older child has been left unsupervised. And even going back as
3 times?
3 or 4 at least. But on top of that, going back, mother's to 2012, I believe, with one of the first 51As filed in this case, mother admitted to the fact that the older daughter would spend a significant amount of time in her pack and play because mother was experiencing those symptoms of depression. And yes, that is in 2012, that is early, but it is an example of what happens when mother is experiencing the severe symptoms of depression. She is physically unable.
What is the I'm still trying to figure out what. Maybe I should take this another way. Why were the children removed from the mother's care?
For a number of reasons. There is not one specific reason, but before, this care and protection was filed in September 2017. And before the department had filed the care and protection, the department worked with mother to address the issues like domestic violence, as well as the supervision issues. In September 2017, this is before the younger child's birth. Sorry, I misspoke on that one. But in September 2017, there was a number of 51As that were filed. And one of those 51As, I think that one of the second one in September, the department and mother came to some agreement that the children would remain in the home, but there were certain conditions that mother had to do. And one of those was making sure that the older daughter was supervised at all times. So even before this, the care and protection was filed, the department had been working with mother to address those issues.
And then when the children were removed from her care, what had happened? What caused the removal?
When they were physically removed, so they were not removed at the time the petition was filed.
I understand that. Yes.
Right. So when they were removed, I think it was the same day that the court, the lower court, granted temporary custody to mother and allowed the children to remain with mother. There was a visit from one of mother's collaterals. I believe it was a parent aide. Mother disclosed to the parent aide that she was feeling overwhelmed, depressed. She wanted to be psychiatrically hospitalized. She had missed several WIC appointments. She had missed pediatric appointments and had run out of formula.
And so the children were removed that day, but placed back with the mother, you're saying that, or no?
No. So that
it was because she was overwhelmed and wanted to be hospitalized.
Not alone, Your Honor. That was sort of a precipitating factor, but given the history, especially with the concerns with the older daughter that were even prior to the filing of the care and protection, it's not that alone, but it's the sort of totality of the circumstances leading up to that incident, as well as that specific incident. And I would point out that although mother identified the need to be, or the desire to be psychiatrically hospitalized, she did not do so. She did not follow up once she had sort of identified that need to be psychiatrically hospitalized.
When did you change the plan to adoption?
Unfortunately, I don't have that off the top of my head.
Do you know why the goal was changed to adoption?
Specifically, it would be because of everything that we've been talking about. We've got the mental health struggles, the fact that mother did not cooperate with the department, the lack of housing. So all of these things.
Okay, but the lack of housing is caused by not having the children.
Not
right?
Necessarily, Your Honor. Here,
not necessarily, but there's no finding by the judge that if she had the children, she couldn't get housing. She had housing before.
Yes, that is true. She did have housing before, and she did lose it, but the department worked with mother. The department made referrals for housing resources to mother, and mother did not follow up on those referrals. So while yes, the fact of not having custody of the children may make it more difficult to obtain housing, the department worked with mother, presented her with resources, yet mother did not follow through with those resources.
Well, she doesn't have the children. I don't understand how she's supposed to get. I mean, I didn't understand housing to be the issue here at all. Are you saying it is? I read your brief to say the issues were domestic violence and lack of supervision. But then when I look, the domestic violence issue, I don't know that it's permanently resolved or what, but that's not in the judge's findings. And the lack of supervision looks to me like, and I'm not saying this is insignificant, that 3 times some years ago, there was no one there for the child when she got home from school. And at least one of the times, the mother was in the hospital having just given birth.
Okay, I have 3 points in response to Your Honor's questions. First, addressing the housing. And again, this is sort of a totality of the circumstances. It is not one factor alone that renders mother unfit. It's a totality of all of these concerns, all of these circumstances. Next, addressing the lack of supervision. Yes, there were 3 or 4 51As that came in from issues stemming from the lack of supervision. And I want to be clear, I'm not counting the one that came in when the younger child was born and mother was at the hospital, because she did attempt to make arrangements. So aside from that, in one of the 51 A's or B's, the child stated that she had been left alone at least 5 times, that she makes her own breakfast, and that mother sleeps during the day. And mother corroborated that with her own statements to that 51B investigator. So respectfully, it's not just those 3 or 4 times that the 51As reflect. There's more to it than that. And it's not simply a lack of supervision. We have a glimpse into the home life there where the child says she's making her own breakfast and her mother sleeps all day.
Look, making your own breakfast better not be a reason for taking kids away from parents.
No, again,
Right?
it's not one reason, but it's insight into what the older daughter's child life was like living with mom. And I believe at that time I want to say she was 4. So
the judge's findings don't say this is a woman who was so depressed that if we allow this older daughter back into the house, the mother's just going to sleep all day and the child will be not attended to. They don't say anything like that.
Correct. And I see my time is approaching the end.
You keep talking because I want to hear more.
I will. So yes, there is no specifically detailed finding that says what Your Honor just stated. However, the findings are there regarding the lack of supervision, regarding mother's symptoms of depression, what she experiences when she is sort of in the throes of depression. And the findings, while not specifically connected by the trial court, the evidence is there. And the department argues that that is enough to support the trial court determination that mother is unfit, as well as it being in the best interest that parental rights be terminated.
The safety factor seems to be a big one in the judge's findings. Can't keep them safe. But it looks to me like all we have is 2 months of visits, maybe 3, October, November, December of 2019. And we're talking about redirecting her, and she tries verbally to get the little one to comply, but doesn't stand on the other side of the street or the sidewalk when the child is walking or something. Do you think that's enough to say she can't keep that child safe?
Yes, because it's not just the issues at the last few months of visitation. Again, looking back to when mother was parenting the children, how her symptoms of depression affected her ability to provide and care and supervise the older child, it's not inappropriate to consider that when assessing whether or not mother will be able to keep.
It seems like until she was pregnant with the younger child, I don't think DCF or a court would have said she was an unfit mother for the older child. Do you disagree with that?
I do. Respectfully, I do disagree. And there are a couple of things that point to that. And we've got a number of 51As coming in before mother was pregnant with the younger child. And a lot of those point to mother's struggles with depression, the fact that she is not adhering to her mental health treatment.
There's a lot of people who struggle with depression.
Yes.
And don't adhere to their medical treatment.
Yes. And again, that's not the only thing. And this is why we need a nexus, which we have here. When mother is not engaged in her treatment, is not taking her medication as prescribed, she experiences the severe symptoms such as sleeping, being late to appointments and things like that, that she testified to and that were also acknowledged other places in the record. So yes, there are people who suffer from mental health disorders, do not necessarily take their medication, but we're not concerned with those people. We're concerned with mother and how her lack of management of her mental health affects her ability to parent her children. And when she's not taking her medication or is inconsistent with her medication, as her entire history shows, she suffers the symptoms of depression, which lead her or put her in a position to not be able to care for either child, either individually or together. And for those reasons, the department would ask that this court affirm the decision of the lower court, and I will rest on my brief.
Okay, thank you very much. Very well argued. Attorney Campbell.
Good afternoon. May it please the court. My name is Alan Campbell, and I represent child 2, the younger child in this case. And child 2 asks that this court affirm the judgment as to him. He takes no position as to mother's arguments as to child 1, nor any position as to child's 1 arguments as those, they just simply don't relate to his custody. And regardless of whether mother is able or unable, again, I'm not taking position, but regardless of whether mother can take care of the older child, she cannot take care of the younger child.
And what's the evidence of that?
The evidence is a series of evidence, a series of findings. But one thing I would like to point out, I believe it was Justice Ditkoff that mentioned it. We have a stipulation of unfitness in May of 2019. On the review and redetermination, the court does not start with a blank slate. It starts with, this is where we are, what has happened since then. And what has happened
the way I read the case law, the judge is supposed to say what the basis was for that stipulation of unfitness, because the burden of proof remains the same. It's on DCF to show by clear and convincing evidence, right?
That was my next point, which was already on here. The judge did that. I included in my addendum an order. It's page 48 of my addendum. It's an order regarding the stipulation, and the factual basis for it was a social worker reports from March 28th, 2018 and February 25th, 2019. It doesn't specifically list the facts from those reports, but it says the basis for this stipulation was those 2 reports.
Counselor,
so there is
even if mom was unfit in May 2019, it doesn't tell us whether mom's still unfit at the time of the trial and likely to remain indefinitely.
Well, it's certainly not determinative, but it's relevant. And then if you look at what happened from when she stipulated in May until the trial in December, his mother did nothing. She stopped her engagement with DCF. She hadn't met with DCF since July of 2019. I believe she had 9 tasks in her service plans. The only 2 that she even argued, well, 1 she definitely complied with. She met with the children. And then the other one that she arguably complied with is she attended some therapy. There are 7 other tasks that she didn't do. She made absolutely 0 effort on any of those other tasks. And as the court's well aware, failure to engage with DCF or failure to work on her problems is evidence of unfitness, or can be considered by the court. And when you consider whether or not it's likely to continue, this case was 3 years old, or 2 years old rather, 2.5 years old by the time of trial. It's not like this was children were removed 2 months later, she's found or there's a stipulation of unfitness, and 6 months later, it's termination. This case has been going on for years. And the younger child had been in mother's custody for a total of 10 days. He's now 5 years old, 10 days in her custody. And some of that time, I believe he was in the hospital. I believe he was actually in her custody and with her for 3 days, from September 22nd to September 25th. And in those 3 days, she had already missed pediatric appointments. She had already missed WIC appointments. She had run out of formula. So mother does not have a great track record of taking care of the younger child. And that was before, well, she also doesn't have a great track record for the older child. If you look at the months leading up to the removal, she wasn't just unsupervised in the house. There are 3 instances, I believe, where the police were involved because the child's wandering around the neighborhood. And I certainly agree with Justice Rubin that making your own breakfast is not grounds for termination. However, at age 6, wandering around, knocking on people's doors, asking somebody to babysit you because mother has court, that I think or suggest is a basis for finding of unfitness. A 6-year-old shouldn't be going up to strangers and saying, hey, can you take care of me? Because I know my mom's not going to be able to tomorrow. That is actually quite egregious. Fortunately, nothing happened to her, but the cases are abundant. We don't have to wait for the children to be seriously harmed before the court will step in to protect them. Mother has a track record of not being able to care for the children. And I will admit, this is not one of those easy cases where the parent is a horrible person and they're regularly beating the children or abusing the children. Mother may very well be a good person. I don't know her. It's clear that she loves the younger child, and that's why we have an order for post-adoption visitation, which the younger child is not opposed, that's great. He can get to see his mother on an ongoing basis. But the question isn't whether mother is a bad person, it's whether she's fit to parent the child, and she simply is not fit to parent the younger child. And again, it was not just the sidewalk incident. As I wrote in my brief, visits went well until they didn't. And they didn't because the child became more mobile because of his diagnosis. Well, it's not because of the diagnosis, but because he has autism, because he is on the spectrum, he requires more care than a typical child would. And even during an hour-long visit in the 3 months before, the 2 months before, where he was more mobile, she was exhibiting on numerous occasions that she wasn't able to safeguard him. So she's had 3 days where he was living at home.
I take it we have nothing in the record that details the nature of the diagnosis or what types of special needs the younger child might have. Is that right?
There's nothing specifically, there isn't a medical report that says it, but the evidence is that he was diagnosed with autism. And I believe that it's safe to say, even without medical testimony, the child with autism has special needs.
Of course.
Exactly what those needs are may not be identified, but she's unable to meet any special needs. So there didn't need to be medical testimony on that or expert evidence on that. And it's important about that, again, being depressed is not a basis for termination. However, having a history of stopping your medications, which you need, because it's not just depression, it's ADD, PTSD, depression, bipolar disorder, and then an IQ of 70, which I guess can't be helped by medication. But she has a history of stopping taking the medications because she doesn't like the side effects and using marijuana instead, I believe.
Now, can I ask you again about the stipulation? I'm looking at your RA or your ad 48. You're saying that it's these reports of 328.18 and 225.19 that are referenced in that first paragraph, that those are the factual basis for the stipulation. Is that right?
That's I mean, I wasn't there, but my reading of it says,
yeah,
these reports are made part of the record.
Okay.
And then just one last very brief point about a question that Justice Ditkoff asked about sibling visitation. There is an order for sibling visitation to occur at least monthly, and my understanding is there have been some hiccups during COVID, but going forward, there is a schedule. I think it's like the 3rd Friday of the month or something, or the 3rd Saturday rather of the month. There's a plan that the children will get together. So sibling visitation should be occurring on a regular basis.
Okay, thank you very much. Your time has expired unless I see any other questions, and I do not. Thank you all very much. These are very hard cases, obviously, for us and for the parties and for you. So we appreciate your excellent and helpful work on them.